সঙ্গে সঙ্গে গিয়ে আজকে লিস্টে চলে এসছো।
My lord,
Yes.
may I be permitted to mention to move on leave? Very urgent motion. My lord, motion is so urgent that the National Highways Authority suddenly, my lord, marked with yellow color to my pillar for demolishing my constructed house G+4 house.
Cannot
My
be
lord,
suddenly notice was served.
no, my lord, no notice has been served. What happens, my lord? They have acquired out of 5 katas of land, they have acquired 1 kata, 3 chatak, 3 square feet of land. My lord, thereafter, they are demarcated portion, they have already constructed the road. Thereafter, my plan has been ratified and verified by the KMDA. Thereafter, it has been gone to the HMC, Howrah Municipal Corporation. They have given me the permission. After getting the permission, I have constructed the house. After that years, my lord, already from their service road, there is a gap of 4 feet. Thereafter, Mala, they have suddenly came to and Mala, they said verbally, without even giving notice, we shall demolish your house any day. Mala, any day they will come and Mala, it has been done on last
Come back, give the number, I'll take it up tomorrow.
Mala, kindly give the leave, otherwise we cannot file it. Now it is so concerned, without Mala leave, the file has not come out.
Leave to file.
Let it be listed tomorrow, Malad, so that Malad, I can Malad serve notice upon the learned lawyer of the.
To mention one matter. Malad, this matter since 2022, it was never been taken up. Motions. Now, when motion is not taken up, now it is appearing in the combined list 2216. Now, when difficulty in this lawsuit, you can see 1.5 years has already passed. But you getting any chance to move before the old.
Are you mentioning of a notice?
When after notice, Malad, I have filed this.
Are you mentioning upon notice?
No, Malad, difficulty is I shall lawsuit after vacation.
No.
I will serve the
Please
notice.
mention after.
Well, I am
to mention upon notice. Not
Only-
mention without service of
Yes,
notice
yes.
to the other side.
Only state is the party, my lord. Now nobody.
Please serve, come back.
My lord, I have served notice. to the other side. I am mentioning one matter, serial number 101. Urgency is this, my lord, after result, no copy was served. Up till now, I made an application before them. In spite of that, they have issued a notice for demolition of my.
Give them.
Malad, I am praying for Malad. For upgradation, long. Malad, for upgradation, Malad, I have served the notice other sides, Malad, for upgradation, Malad. Long-term lease agreement, my lord also.
Upon notice.
Yes, Malad, I have served mentioned, Malad. Also annex Malad notice, Malad.
Well, Oshu's kind indulgence to mention one matter for extension of interim order, my lord. My other side is present, my lord. So I could not be able to let it appear tomorrow, my lord, for extension.
Upon notice?
I am mentioned what
Other side present, other side present.
Served?
Malad, item 86 of today's list losses matter had been taken up about 2023 losses.
Are you mentioning upon notice?
Direction already, Malad.
Are you mentioning upon notice?
Malad, Mr. Chondi Charan there.
Yes, so you have to serve notice and then mention.
Madam, mention one extension of interim order, my lord. Extension of interim order.
Upon notice?
Yes. Tomorrow you will explain.
With my lord's
Extension of interim order.
with my lord's kind leave to mention, my lord, one application I have served notice, I have annexed the notice.
Application for?
Application for recalling, my lord. The recalling.
May I be, may,
Applications after vacation. Have you seen the mentioning list size? So many matters under the heading mentioning also, mention matters also. Why didn't you come back after vacation?
My lord,
Because it's a
come in the due course. Then in that case, it come in the due course, my lord.
recalling application, it will need some time, isn't it?
Well, my lord, let it come in the due course then, my lord.
Immediately after vacation, please mention and take it.
Then I'll mention it after the vacation.
Why lend them
May
may I be permitted to mention, my lord?
Oh, why? Why are
When the private respondent has enclosed the land, we have arbitrarily occupied by land. And the DM has ordered, but still they have not.
give the number? I do not know how these
May I be permitted to mention, my lord?
upon notice. Give the number.
My lord, may I be permitted to mention, my lord, for upgradation, I have served notice upon the other sides, my lord. District magistrate has acquired the land. No compensation has been given. Similar order has been passed by this honorable court in a similar matter, my lord.
can give the number, it will be better if you can wait till the vacation.
My lord, may be permitted to mention.
My lord,
I can include it in the list, but you've seen the list.
I have served the notice upon order.
I'm happy with that.
My lord,
May
for
I
inclusion.
Yes, Mr. Bhatt.
In my chance, not with notice. For upgradation, I shall come with. My lord, only thing is, my lord, 519 to 522. There's some urgency in the matter. I won't say great urgency, but urgency in the sense, my lord, national highways have, my lord, initiated proceedings, compensation paid. I am not satisfied with the compensation. I am saying that the demarcation has not been done properly. I am entitled to more money. Now, my lord, I am obliged to return the land, my lord, on this first week of January, second or third of January. Now, my lord, in the event the land is, my lord, parted with, then, my lord, there will be no fresh demarcation.
Mention upon notice to the.
My lord, I'll come back tomorrow, my lord.
My lord,
take note.
Upgradation, my lord. Item number 597, extreme urgencies, my lord, the PWD department is constructing a bridge over my property and from Sunday.
Are you mentioning upon notice?
Yes, my lord. And they have started demolition proceeding, my lord.
Give the
My
number.
lord, under prevailing circumstances, my lord, I am playing for your leave. My lord, today is feast for demolition, my lord, under 10-4, which was filed by me, but no notice of hearing has already no was had
Demolition notice.
My lord,
please show
this
me.
is the demolition notice, my lord, on first, my lord, yesterday I came to know that order has been passed
Please
in
show me the
absence of.
notice. The demolition notice. 15 days from 1st November.
Yes.
Nothing has happened till now. File and come back, I'll consider.
My lord, yesterday
is not
when
necessary.
yesterday when police came, my lord, I came to know order has been passed behind my back. No
File and come
15
back.
days from first.
File.
Mosquito breeding place, which is a silent carriers of dengue, and it is necessary to clean the garbage and removing the small bushes.
How is this court, how does this court have determination? Cleaning of garbage?
My lord, we have given letter to the chief municipal
How does it
office.
come under group 1? Please explain.
But my lord, this was
Come under group 1 at all.
my lord, this was running in the list. It got delisted on 21st September 2023.
Maybe because of that reason it got delisted. Please find out.
No, my lord, there was an order on the opposite party to file affidavit in opposition within 2 weeks of the vacation. But till today, they have not filed any affidavit in opposition. That's why.
Please come back after vacation in that.
My lord,
may I permit
my lord,
mention
without
that
me,
officer?
my lord, they did not take the copy of the application. My lord, I
File and come back. It first November order. File and come back, I'll consider.
My lord, may I permit it?
Yes.
My lord, upon notice to the other side, my lord, the petitioner is a registered company, my lord, and he has the petitioner has purchased one property, my lord, from the several individuals of this for the purpose of the development for commercial purposes, my lord. My lord, the petitioner suddenly came to know from our official gazette notification that the plot has been come under the wetland as per the Kolkata Wetland Conservation and Management Act 2006, my lord. My lord, after finding the petitioner found that the entire proper land from where the petitioner purchased the property has already been developed earlier for commercial purpose, and there is no evidence that it contains any water body, my lord. Where several representation has been made, my lord. My lord, the fact remains that it is running in the daily supplementary list from 194 item number since last 4 months, my lord.
You
There's
mentioned
great
upon
urgency.
notice.
Yes, my lord.
Give the number.
My lord, that's another matter for non-prosecution, my lord.
Non-prosecution upon notice?
Yes, my lord.
Shantanu, non-prosecution আছে একটা।
Item number 86, my lord, of today's list.
Yes. What is your urgency?
Uh,
Are you mentioning upon notice?
Yes,
The other side?
Lordship, for upgradation, my lord, my egress and ingress, my lord, enforced by the private
The
estate.
number?
Kindly give it to me.
What is your urgency?
Are
Are you mentioning upon notice to the other side? Yes.
And my lord, and you will not updated the matter. And my lord, on 30th December, the matter and my lord, two matter were disposed of, and one matter you will also remember that the track record does not show whether the notice was
Served on.
And my lord, therefore, your lordship directed that the matter will appear in today because it is a short matter, only consideration matter. Therefore, I found that the matter has gone in the motion.
Mentioned matter, only one day it will appear as mentioned matter. From the next day onwards, it will be under the heading motion. Mentioned matters will not appear in.
I will allow it appears in the motion matter.
Are you mentioning upon notice?
Yes, ma'am.
Give the number.
Lordship,
Yes.
I will permit to mention. Lordship, this is for extension of interim order, Your Lordship.
Upon notice.
Upon notice, Your Lordship.
Extension of interim order.
I'm grateful, Your Lordship.
You're mentioning upon notice? Yes? You're mentioning upon notice to the other side? Why are you asking for upgradation? What is the urgency? Give the number, please. Give the number, please.
Lordship, I just mentioned the notice is not annexed with the mentioning slip, Your Lordship.
Not be taken up, sir. without
Lordship,
the notice.
I just need to take a printout. I'll just take the printout. I'll be back in 5 minutes.
আলাদা রাখুন, উনি নোটিশটা দিলে ওটাই করুন।
I'm grateful, Your Lordship.
My lord, may I be permitted to mention a matter? My lord, it's for upgradation, my lord. My lord, in this matter, the land of petitioner was acquired by the authorities for implementation of drainage system 50 years back, my lord. My lord, but till date, no implementation had been done.
Mentioning upon notice?
Yes, my lord.
Give the number.
My lord, may I be permitted? Lord, for upgradation, lordship, item number 119, totally, lordship. The fact is that lordship, the private investment concerned over the PWD.
Mentioning upon notice?
May I mention, my lord?
Yes.
It is a contempt matter, enlisting new contempt matter, and more than 3 months have been passed away for the stipulated time. The respondent have not.
It's a new contempt.
It's a new
the number.
contempt.
Give the number. Yes, call the Jalpaiguri.
Yes, I am mentioning one matter. This is the matter is related Jolkor tender matter. Earlier official matter.
You're mentioning upon notice?
Yes, madam.
Give the number.
My lord, may I be permitted to mention one matter, my lord?
Yes.
Your lordship will take mention matter at 12:30 on
Yes.
Wednesday and Thursday, my lord. Your lordship will take mention matter at 11:30.
What?
And because, my lord, there are so many mention matter is pending, my lord.
For the motion
Because-
is suffered.
My lord, they are the old motion, and my lord, mentioning matter is urgent matter, my lord. They are mentioning only for that is, my lord, I pray before your lordship on behalf of the bar. If your lordship will consider our
Is it at the bar?
yes.
12 o'clock. 12
Matter always, my lord, prior to vacation, my lord, is
But the entire list is getting into mention matter.
My lord, that
difficult.
is the
for such
problem.
reason we are before your lordship.
12 o'clock.
Yes, my lord.
শান্তনু, কাল থেকে mention matters at 12 noon. 12 noon. In any case, I'll be taking up motions these 4 days.
That will be.
No use taking up hearing matters before the vacation. Yes, this is Jalpaiguri Circuit Bench. Contempt
Calling
matter.
from Jalpaiguri list matter item number 1.
Yes.
Shivam for the petition.
Is it a new content?
Lordship, contempt.
You are for the applicant?
Yes, Lordship.
Have you served?
Yes, Lordship.
What is the
For
number?
earlier order, Lordship, affidavit of the report.
What is the number? Is it 66 of 2023?
Yes, Lordship.
It has been disposed of. Oh no. Who is appearing for the contender? The alleged contender? Shaunak Bhattacharya, Deepthankar Mukherjee, who are they? Yes? For the contemner?
Lordship,
Have you received a copy of the report?
Lordship,
Yes.
they have filed one report which is
Yes.
not subsequent to the report of your Lordship, first of all. Rather, it was filed after the contempt application on 2000.
I am for the alleged contemner, my lord. I am led by Mr. Shaunak Bhattacharya. My lord, order has been complied. Kindly makes it a short passover. I shall file the complaint.
What is this that you are filing today?
Lordship,
Lord, he's appearing
taken up
before
to
court.
2023, one report has
Yes.
served upon the petitioner.
Yes, my lord. That is the compliance report, I hope.
And the Lordship order was on 15/6/2023.
Where is the order disposing of the representation? Yes.
There is no such order, Lordship, only
I do not find any order, right?
Lordship, it's been 10 years. My amount is pending with them.
This is a notice. Where is the order? There was a direction to dispose of the representation.
My lord, kindly makes it short passover. I shall take necessary instructions, my lord. Short passover, my lord. He's appearing before courtroom number 9.
Not
5
today.
minutes.
Not today. Tomorrow 10:30. Otherwise, necessary order will be passed.
Grateful, Lordship.
এটা ফেরত দিয়ে দিন কালকে।
কালকে থাকবে।
Not today. Next.
Calling from item number 1.
Well, this matter is appearing at my instance. I'm sorry, I've lost my voice. Well, this is for modification of an order passed in this writ application. Put very briefly, my lord, way back in 2010, there was an order by a coordinate bench directing my clients to put in a bank guarantee towards forfeit charges and stacking charges. Well, 48 lakhs bank guarantee had been put by me. The next date of renewal is 4th January 2024. Now, my lord, I have received instructions on news to the effect that the goods which were supposed to be retained in respect whereof I gave the bank guarantee are no longer available. I wrote a letter, my lord, to the railway authorities asking them to reply as to what has happened to the goods, because accordingly, there's no point in keeping the bank guarantee alive if my goods are gone. There is no reply for them.
What do you mean by the goods are gone? Where are the goods?
I don't know. The railways will know. It was kept in their custody. So I've taken out a formal application for modification of that order, but let the railways tell your lordship today, my lord, whether the goods are there or not.
You are subject to lordship's kind sanction.
Yes.
My lord, regarding the warfares, my lord, and the stacking charges. Now, this is not the forum where it is to be decided. My lord, it has been decided in a division bench. If your lordship kindly see.
My lord, let this
They have to approach before the railway rates tribunal. My lord, that is, my lord, under section 33 and 36. My lord, it has been
My lord, let
decided.
this application appear in the list. Let me show your lordship, my lord, the submission, what he tries to make,
This has been
because the question is,
decided.
he should at least, my lord, at least write me a letter saying that do this or don't do that. He keeps quiet. And my lord, I have incurred expenses of 16 lakhs of rupees, my lord, keeping the bank guarantee alive for all these years.
When have you filed your application?
Well, this application was filed. It was mentioned several times before your lordship. Can 2 of 2023.
Was affirmed on 2nd September 2023.
2nd September 2023. Well, at any day or, my lord, on the reopening date, my lord.
This is primarily a land matter, group 1 matter? No? Then?
This is against the railways.
Railways, my lord, group
That's
3, I
group
believe.
7, I think.
Group 3, my lord, group 7, group 7.
Should be group 7.
Group 7.
Because it's a 2010 matter. That's
Yes.
I do not find your application on it.
Yes, my lord, it is scan number 2 of 2023.
And
Can 2. No, the can is not appearing.
no can is not there.
देखिए
List e ache.
my lord, in that case, my lord, let it appear on the reopening the copy. I shall replace it with the original. My lord, I'm sure it's
2nd of January.
2nd of January and the reopening date. My lord, let it appear in its, let it retain its position. It will take 10 minutes, my lord, and we shall dispose of the matter.
Subject to correction, my lord, may I submit one thing, my lord? Subject to correction, the can 2 is listed in the to be mentioned today.
You cannot make your submission from a car. That has been seriously treated by the Honorable Supreme Court. Please do not.
I really apologize, my lord.
Mute him. Mute him immediately.
Can 2 of 2023 is not in the file. Paragraph, the department is directed to
Remove korun.
put up the application along with the file on the adjourned date. Paragraph, let the matter appear under the same heading on 2nd January 2024.
Well, the affidavit of service may be kept in the records, my lord.
Suppose you can take back the copy, I think, because I'll take
Very
I'll
well.
take the original.
I'm very grateful to my lord.
Yes, next matter.
I'm grateful.
Next matter.
Item number 2.
Item number 2, I beg to appear on behalf of the respondent, my lord. Respondent number.
Appearing from your vehicle, sir. You are sitting in your car.
My lord. My lord, this is a non-prosecution matter.
Are you allowed to do that? Does the decorum permit so?
I'm sorry, my lord, I beg your lordship's pardon.
Item number 2, my lord, I am for the petitioner.
What practice is this? It will be from the bedroom, sitting room, from anywhere now.
I am for the petitioner in this matter, my lord.
You want to withdraw?
Yes, only petitioner number 1 wants to withdraw. There are 14 petitioners. Out of them, the petitioner number 1 wants to withdraw.
What about the others?
Others will contest the case. Yes, this is a acquisition proceedings.
Yes.
Only petitioner number 1 wants to withdraw.
I am giving the.
And you are appearing for all the petitioners?
Yes.
Learned counsel for the petitioners submits that the first petitioner does not intend to proceed with the matter any further. The other petitioners shall continue with the matter. Paragraph in view of the above. You have submitted
Yes, yes.
instructions submitted by the first petitioner. Paragraph is taken on record. Paragraph in view of the above. Liberty is granted to the first petitioner to withdraw from the writ petition as prayed for. Urgent certified website copy. Out of list আছে আর কিছু দরকার নেই। পড়া আছে আর কিছু দরকার নেই। খালি urgent certified website.
Yes.
Yes, next one.
Item number 3. See, my lord, I have mentioned this matter for release. Wrongly, it is. This is a group 5 matter, my lord. This is a tender. It should be group 5, my lord. It has wrongly been filed, my lord, before lordship, my lord.
Correct the presentation form.
Yes, I have to correct the leave may be granted to correct the presentation form and matter be released from the list.
On prayer of the petitioners, leave is granted to correct the presentation form of the writ petition. Paragraph, the matter pertains to group 5 of the classification list. Paragraph, the matter be released due to lack of determination.
Grateful to you.
Next.
number 4.
Is my application for restoration. Lordship,
Have you
there are two brothers, both the application was dismissed, one is already restored. Kindly see the order. passed by- No, my lord, no other side. My lordship, kindly see the order already passed, 4508 and this is 4509. This order, I am bringing this order, my lordship may pass.
This is an application for restoration, can one, huh? Then restoration of the writ petition which was dismissed for default by an order passed on 4th July 2023. Paragraph, sufficient grounds being made out, comma, the application is allowed. Paragraph, the
My lord, one
order
thing,
dated
my lord, one thing, my lord, I pay for the withdrawal of this application and liberty to file afresh because there is some the problem in this writ petition.
John, the order dated 4th July 2023 is set aside. Paragraph, the writ petition is restored to its original file and number. Can such and such is disposed of. WPA the order করুন. Learned counsel for the counsel to check it. The petitioner seeks to withdraw the writ petition on account of certain defects detected
Well.
therein and seeks further liberty to file a fresh writ petition on the same cause of action.
My lord.
Paragraph, in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to file a fresh writ petition on the same cause of action. Paragraph, there shall however be no arrest to costs as in certified website.
Yeah.
Wait at the complaints.
Item number 5.
Number 5, I beg to appear for the petitioner. My lord, if my lord recalls, this is that application where there was a direction for direct purchase of the land acquired. My lord, since it was not done, contempt was filed, review filed twice, my lord, review withdrawn twice, and now, my lord, I have been handed over a affidavit of compliance, but it says compliance, but this is not a compliance report. This is a progress report rather.
My lord, kindly come to page 11, my lord.
11 of the
Complaints report, my lord, which I have handed over just now. my lord.
Yes. The minutes.
Agenda 1, my lord. Department, then my lord, agenda 1. First column, my lord.
This is the agenda, what has been done.
Yes.
My lord, kindly see. আমি বলিনি তো আপনি
না বলুন বলুন আপনি বলুন না
The proposal for direct purchase, more or less, the description of the land is given, my lord. The decision, proposal contained para 7, cabinet memo, it has been approved, my lord. Cabinet has approved the proposal, my lord. The money fund will be deposited in the treasury, my lord, and it will be dispersed, my lord. We have taken the account details of the petitioner, my lord. Everything has been done.
Where does it record that the cabinet has approved?
My lord, kindly see the agenda, then decision, my lord.
Decision.
My lord. Proposal contained in para 07, read with 0506 of the cabinet memo was approved. Cabinet has approved, my lord.
How much more time do you require?
My lord, at least
I
two.
want to see a complete.
My lord, at least 2 months, my lord, is required. At least 2 months, my lord. My lord, for payment, my lord.
Why? It has been approved
Well,
already.
it has been approved. My lord,
The fund will be placed by the
fine
recording
will be
body.
placed before the treasury, my lord, and it will be dispersed.
Why do you need 2 months? I'll give you 1 more month.
Thank you, lord.
Otherwise, I have to issue rule. It has to be
My lord, my instruction is it will take, my lord, 2 months, my lord. That's why I submitted.
2 months. There is no question.
It has been approved by the cabinet, my lord. I have placed, my lord.
Since 2020.
My lord, I know, my lord. My lord, approval has been done on 4th December.
Yes, today we are already on 19th.
Then it will be remitted back to the Secretary of Finance and then it will come to the Treasury. The lordship knows the process, my lord.
It has to be you have to speed up the procedure, isn't
But
it?
they are in between that, my lord, the winter vacation will be there, my lord. Now, kindly consider that aspect also, my lord.
The government department doesn't have a winter vacation.
No, my lord. What make you laugh? I don't know.
my lord, kindly see the explanation that has been given in the
1 more month.
Now, kindly,
It has progressed. Let us see.
kindly give some more time, my lord. Kindly, my lord. Some more time, my lord.
I'll give you till end of January.
As your lord.
No further time.
As your lord.
Affidavit of compliance submitted on behalf of the alleged contemner is taken on record. Paragraph, it is submitted on behalf of the alleged contemner that the proposal for direct purchase has been approved by the cabinet. And the land value shall be disbursed in favor of the applicant petitioner upon receiving the same from the requiring body.
My lord.
Learned counsel seeks accommodation to comply with the order under contempt in its entirety. Paragraph. As a last chance, the prayer is allowed. Paragraph, let the matter appear under the same heading on 30th January. 30.
30th January. April.
Next.
Item number 6.
Lordship, Your Lordship, I have served the new incumbent. The track report showing it has
Who
been
is
delivered.
appearing for the alleged contemner? Who is
Alleged
appearing?
contemner is the executive engineer, South 24 Parganas, PWD government. Also, initially I have implemented the executive engineer, South 24 Highway Division, PWD roads. Subsequently, a letter dated Lordship 26 September 22. Lordship, the concerned executive engineer, Lordship, intimated my client that this Lordship, the officer I have sent this contempt application is now in charge of this project.
So now it should be executive engineer, South 24 Parganas Division, PWD.
PWD, that's why I have served.
You have not added him. Not added him in the contempt application.
Lots of have served. Lots of then let a amendment application be filed because
You can add it. Amend the cost title, I'll grant you liberty.
to add this particular officer as the party. And also, I'm praying for liberty to lots of the forward the copy to the learned advocate who appeared in the writ petition. That will be better.
You were granted liberty to implead the executive engineer. Please do the necessary corrections, that's all. On 6th September, you were granted liberty to implead the executive engineer, South 24 Parganas, PWD. Order dated 6th September 2023. So please do the necessary corrections in the cost title. And who is the executive engineer? The name. It's a contempt application.
They'll also kindly allow me to file an addition of party because name I have to collect it.
Because you have served the executive engineer. You have to serve
In the name,
person.
in the name of the post,
You
yes.
have to serve the
Name of
person.
the post.
You can take this back. Addition of party is not required because I have granted you liberty to add him as a second alleged contemner. You have to make corrections with the name. I'll just adjourn the matter today.
So I have to collect the name of.
Collect the name in the meantime and then make the corrections. Liberty is already granted. On prayer of the applicant's petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 10th January. Please do the corrections and then
By
send the
in
notice.
course of tomorrow.
Yes. Next.
Item number 7. My lord, in this matter, I am for the petitioner.
Today I am filing a compliance report.
Complaint.
Yes.
My lord, I have to make some submissions.
Yes, yes.
Not
yes.
today, because what happened, my lord? The BLRO has a such authority to set aside my lord order. But anyway, I will not go through the entire judgment. A long order has been passed. I have to, my lord, certainly I will go through the my lord's that's order. Then my lord, he is acted as appeal court. However, lordship.
It's an exception to the.
Yes. I never come across such an order can BLR pass against the order judgment of a high court. BLR can pass a judgment that this order is not sustainable. But I'm sorry to say, but so that's why I put on 4th of January, lordship fixed it.
Not 4th, I'll fix a date.
Order has been passed by the special landing officer.
Anyway, special officer.
Special landing
He's not above the high court. I think so. So far, my practice is concerned. 45 years of practice, I never seen such an
Affidavit of
audacity of a
on behalf of the alleged
administrative officer.
Paragraph, learned counsel for the applicant petitioners seeks to use an exception to the affidavit. Paragraph, let the matter appear under the same heading on 10th January.
10 January. Grateful, man. Grateful.
Please serve an advance copy so that.
Definitely. Certainly.
Next.
Item number 8. Well, in this matter, I am happy to the new contempt.
Will you serve and come back?
Yes.
The applicant petitioner is directed to serve copy of the contempt application along with annexure thereto upon the alleged contemner and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 11th January.
11. Next matter is the same. Item number 9.
Same order.
11th January. Deeply obliged. Item number 10.
You are the petitioner?
Yes.
You are
এদিকে সরো একটু this is a case of
a minute, please. I'll just take the.
yes. I'm sorry, man. I'm sorry. The 944 পাতাটাকে বার করো.
Who is appearing for the respondents?
Mr. Ansar Mundal is appearing. 944. Well, this is a case where a marginalized scheduled tribe, he had a parcel of land in a forest area, and then suddenly he didn't know what has happened to the entire part. One day he finds that there's a building raised by the forest department. So he puts in a requisition. He puts in under the RTI Act. And the RTI Act, in the RTI Act is specified that there is a building standing on your land. So then he makes another RTI and he says whether it was acquisitioned or not, or whether the procedure was followed or not, because I have had no notice of the entire procedure. Nothing was given. It was stated that you give me the number of your case. Now, if I had a notice, I would have given the number of the case or the acquisition case. Now, in these cases, the government is very clear that you cannot take this kind of land unless it's an extreme measure, and the guidelines are very much, I have the guidelines. Now, I'll take your lordship.
I do not find the respondents being represented today.
My lord, I have a report on the last, quite a few occasions back.
Very unfortunate. Mr. Mondol's junior is also not, no one is there.
On the last occasion, he did take time. I was here.
Let me give another date. I'll record that it will be taken up for hearing even in absence of the respondents on the next day. Yes?
That'll be right.
Another last chance.
Actually, my lord, these cases are practically pro bono cases, my lord, every time. We get nothing out of it, my lord. It's just a reputation.
Another date. Just one last date. And none appears for the respondents. Stop. No accommodation is sought. paragraph, let the matter appear under the same heading on 11 January. Paragraph, it is made clear that the matter may be taken up for consideration on the adjourned date, even in absence of the respondents.
Grateful, grateful.
Next.
Item number 11.
Lord, I am for the petition.
Respondents?
I am for the Jela Parishad, Birbhum Jela Parishad. I was directed to file my opposition. I am ready with my opposition.
A report.
Submit a report.
Report.
On a land without acquisition of land, he cannot construct over the land. In spite of the given
That I have taken
undertaking,
the point, Madam, acquisition not required. In this case, in this type of case.
he will take my land without any acquisition, without giving any compensation. This is the scheme. This scheme is only
This is
existing
Pradhan
road.
Mantri Sadak Yojana.
Existing road will be
It's
Black
not required.
top.
Acquisition not required.
There is no road. There is no road.
আপনি কি নেবেন কপি একটা?
কপি তো নেবই।
আপনি কি আজকে আর্গুমেন্ট করবেন তো?
না শেষ কর। This is the photograph. Without
You are filing the report today?
Yes, ma'am.
Without
I have submitted before your lordship the report. My contention is this: in Pradhan Mantri Sadak Yojana, acquisition not required.
Yes, I admit it.
It's also not required.
That
I admit
acquisition not required. We have taken verbal consent for because it is a public interest. For that is it is a public interest. Sadak. It has to be widened.
There should be a deed of gift if no compensation is to be paid.
Yes.
Otherwise, you
Deed
pay
of gift.
compensation.
Yes, your
No,
lordship.
I give it to your lordship. I have taken that one.
Pradhan Mantri Sadak Yojana, my lord, existing road will be either concrete or blacktop. Where there is no existing road, that Pradhan Mantri Sadak Yojana cannot be expend the money.
The authority says that the work has been suspended.
Yes, they have said, undertaking before the court, we will not be constructed furthermore. In spite of that, they have completed the road. By force.
There is no road. You say then again you say they have completed the road.
But there is no road. They have
So how do you say they have completed the road?
My lord,
You say there is no road.
no road.
You again submit that they have completed the road. That means there is a road.
There is no road. They have by force damaging our crops. They have completed the road. In spite of the undertaking before the court, we will not furthermore. Your lordship, can is a recorded order was there. রাস্তা ভেঙে দিবে তো রাস্তা ভাঙবে না কেন হ্যাঁ this road will be demolished immediately আর এটা বীরভূম জেলা করতে পারেন বাই ফোর্স না প্রভিশন নেই ঠিকই তো অ্যাকুইজিশন কোনো প্রভিশন নেই এই রাস্তা ভেঙে দিতে হবে দিয়েছে ভেঙে দিয়েছে সেম অর্ডার হবে অর্ডারটা আছে নেবো অর্ডারটা নিয়ে দেবো
Your report doesn't say that you have taken even verbal consent. Where is that recorded? In your report?
Verbal consent. Report says. Thereafter, they have given the consent. I am not saying this person. There are many persons there, along with the local Gram Panchayat. All of them came down for the road, and we have taken consent. Thereafter, we have done.
Where is the consent?
That is verbal consent, madam. That is.
Gram Panchayat also gives verbal consent?
Then I have to find out that whether Gram Panchayat has given any consent or not. Gram Panchayat must have given any consent because public persons should not give any consent in writing. That cannot be. But Gram Panchayat ought to have given any consent.
You take away the petitioner's land and you cannot show a scrap of paper showing that he consented to it. What is the consequence? You have admittedly taken away the petitioner's
Yes,
land
madam.
for the construction. Petitioner has not consented to it because I do not find any
The
document.
petitioner says that I have not consented, and that is to be taken that he has not consented.
Yes. So what is the consequence?
That
I have to see whether Gram Panchayat has given any consent or not.
Gram Panchayat has no right.
That is immaterial.
Immaterial.
Gram Panchayat cannot give consent over petitioner's land.
Yes, madam.
Isn't
Yes,
it?
madam. Deeply applied.
What is your prayer?
To demolish. At that time, they have started
Only
construction.
the part of the petitioner's land, they required that is to be demolished, not the others. Only the petitioner.
Petition, Harman petition.
Will you demolish or will you pay compensation for it?
Well, let it be demolished.
Demolish, it will cause
Let it be demolished.
It's a public road.
public road.
So the court cannot direct demolition of a portion of a public road.
Court can direct everything, man. That is
Your
not that.
Lordship,
Court can direct.
My
That
understand-
is that. Court can direct.
Cannot direct everything.
My lord,
That's
I
a-
have
If your lordship directs me that compensation is required to be given, if it is so,
your lordships,
we will compute it and we will then pay them.
my
Only the
lordship,
petitioner,
your
man.
lordship has passed an order.
Only the petitioner, because it
When
is not
there
a,
is a no,
it is not a public interest litigation. They all people came. It is the petitioner himself whose land is gone.
not
He
himself,
will
5 to
he will show that his what land is given. We will compute it and we will pay.
your lordship has already passed an order earlier
What order?
for demolish the road. Where there is no provision.
That is entire road. A portion of the road cannot be demolished.
No, the entire road be demolished.
Well,
there
for
is a
his
7
prayer,
parts.
entire road is to be demolished.
Yes, yes.
And when there is not a
Not my
public
prayer,
interest,
my lord.
when it is not a
7
public
person
interest,
is the petitioner.
So with the order, I can find lot of
Yes, yes.
amicus.
Hey,
curiae.
hey, hey, order to be-
Yes.
Cannot be passed an order in case of Bakuda Jela Parishad. Because they submitted that they are not been in a position to pay compensation. They want to demolish the road. That is why Lordship passed that order.
They want to demolish the road. That is on prayer of the Jila Parishad.
Jela Parishad submitted that they want
Yes.
to demolish that road.
If they want to demolish, they can. They are here. They don't want to demolish the road because the road runs through the land of various persons. A portion of the road is on
portion of the land is
a portion cannot be directed to
a
be demolished.
portion belongs to them.
That order was passed by my lord, a portion of the road, which fall under
No. In that case,
Yes, yes, yes.
it has
That was-
public
it is
interest
a-
litigation.
No,
All
no.
road is to be demolished.
By force. with
All
threat
road.
they have
He wants the entire road
Please take necessary instructions as to whether you will pay compensation to
the
petitioner
to the petitioner.
for that particular portion taken away from the petitioner, or you can demolish the portion of the
My lord, I will
land.
take only this part of instruction. My lord, note it
Whether
in the
you are in a position to demolish or pay compensation.
only, my lord, only note it in the order. But it is only in the case of the petitioner. It will be, my lord.
Yes, because in this petition is only the
Well, there are 7 petitioners.
7 petitioners, they have, I think, they have already paid the court fees also.
report in the form of affidavit
এখানে দিয়ে
submitted
দেবো
on
2
behalf of-
টাকা।
দিয়ে দেবে, সেটা দিতে হবে তোমাকে।
এই 2 কোটি টাকা দাও, আমি 2
2 কোটি টাকা compensation?
Paragraph, the petitioners submit
2000 টাকা
that
compensation?
their land has been taken away by the Jila Parishad
2000 টাকা বেশি
for
একটা
construction, and a road constructed therein,
ও, আমাকেই দিয়ে দিতে ধরো।
though the land was not acquired by due process.
হ্যাঁ।
Paragraph,
Their price-
Learned Counsel for the Jila Parishad submits that
Hey,
no
Jai Sahib.
acquisition is required
এই জয় সাহেবই বলে।
for construction under the
আমাদেরকে compute
Pradhan Mantri Gram Sadak Yojana, na?
Yes,
The name is
প্রধানমন্ত্রী গ্রাম
Pradhan
সড়ক
Mantri
যোজনা।
Gram Sadak Yojana.
এটা আমি দেখি কি
পুরো দেবে না। Learned Counsel seeks to take instructions whether the authority
দাও না, বাকিদেরকে আমি রেট ফাইল
is in a position to pay compensation to the petitioners for utilization of their land or demolish the portion of the road running through the petitioners asset for apostrophe land.
জড়ো করাটা বিরাট ব্যাপার।
Only this instruction is
মানে
left
only that.
because
but-
these are the two options that you are left with.
Well, returnable on?
Paragraph, let the matter appear under the same heading on 11 January.
My lord, you have to
Yes, yes,
Come.
আমার আরেকটু কি?
আরে আমাকে নিতে হবে তো টাইম। ওহ
17th.
আন্ডারটেকিং দিয়েছিল আর করবো না আর।
কত দেবো 200?
Next.
কত দেবো?
70, হ্যাঁ?
হ্যাঁ, ছবিটা ফেরত দিন।
তুমি ছিলে?
ফটোটা থাকবে? ফটোটা থাকবে?
ফটোগ্রাফটা ফেরত দিন।
ওর পোর্শন তো হয়।
ফটোগ্রাফটা ফেরত দিয়ে দিন। এটা দরকার নেই।
Item number 12.
On the other day, this matter was taken up when a report was submitted by Mr. Dhor, stating that the petitioner was present at the time of measurement of the land. The point has been taken that While taking measurement, my lord, no, the petitioner was not called for, but he was there, my lord.
Not
From the
there.
report, it
He was
appeared.
not there, my lord, because of the bereavement in the family, my lord. He lost his mother. My lord, I could not get instruction. My lord, your lordship kindly grant me time. Next date, your lordship kindly.
You're asking for adjournment today?
My lord, your lordship kindly adjourn the matter.
You are for the petitioner?
I am for the petition.
Yes, yes.
My lord,
Whether?
my lord, 10th of January, 11th January, your lordship kindly.
I do not find anyone for the respondents also today.
My lord, I am appearing for, my lord, Bakuda municipality. My lord, already the report has been submitted. I think in their
There is a
absence of state
there is
also
something-
it may be
there
taken
is
up.
something, my lord, I can place before lordship, but in absence of instruction, I cannot do it.
None appears for the state respondents. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 11 January.
My lord, let a notice be served, my learned friend, upon the state. Otherwise, my lord,
Why? He was there on the next day, on the earlier date. Notice
He
should
was
not be
there.
served for every occasion. That should not be the practice. It's the state's responsibility
my lord,
also.
in absence of state, my lord, it can be taken up because, my lord, state has already, my lord, discharged their duty.
Absence of the state. Next.
Item number 13. I am denied. Beg to appear for the statement.
Item number 13, my lord, I am appearing for the National Highways Authority.
My lord,
Yes.
and the affidavit was to be filed by the respondent number 8. A copy has been given to the petitioner, my lord, and today he is present in court, my lord.
Yes.
My lord will kindly take the affidavit. My lord, your lordship's order, my lord, has been mentioned in paragraph number 2. Kindly takes from paragraph number 3.
September 4 order was for demarcation, isn't it?
Yes, my lord, demarcation by the respondent number 8.
Demarcation has been made.
My lord, it has been made, my lord, after the affidavit has been approved on 16th of December 2023, my lord, in the presence of the petitioner.
Yes.
My lord, may I hand over the demarcation report as well?
But I want a copy of the report. ওটা দিও আমাকে।
Hey, develop. Hey, develop.
What is the prayer in the report?
কি বলেছে পড়েছে?
The prayer is for payment of compensation.
Yes, my lord, your lordship will kindly take, my lord, the fresh demarcation report of 16th of December.
Yes.
Kindly take towards the bottom where serial number 1 and 2 is mentioned. Now, my lord, your lordship will kindly see that LR plot number 907 or so and so is not involved with the pipeline of the CHE department. My lord, this is the plot of the petition. My lord, the pipeline is running through 908 and 909. My lord, in the demarcation report, if your lordship kindly takes the 6th page.
Sixth page?
6th page, my lord, after the signature. My lord. There's a attendance sheet just there after.
Yes.
My lord, there's a
page
map.
Yes.
Your lordship will find, my lord,
907 is left out.
Okay, my lord, 907 is not where pipeline is going, my lord. The highway is there, then a relay line is there, and the petitioner plot falls just outside the relay line.
Petitioner is claiming over 906, 7, 8, 9, 10. Total 37 decimals. Yes?
Just now I have received the report. But
Yes.
they have stated your lords will take the matter just now, and I shall go through the
Want
same
to go through the report and
as because what they have stated. Now,
Petitioner is
what
claiming on all these lines. Page 4 of the writ petition.
My lord,
in the earlier
go
report,
through the report
on
also,
the
my lord,
earlier
I will,
report,
my lord, reconcile both the statements with the writ petition.
Please do that. Please do that. Yes. Affidavit of compliance and demarcation report submitted by the 8th respondent is taken on record. Or the 8th respondent is present before this court. Personally, present before this court. Therefore, taken on record. Paragraph, learned counsel for the petitioner seeks to peruse the report before making any further submission. Paragraph, let the matter appear under the same heading on 15 January
15 January.
2024. Paragraph, personal appearance of the 8th respondent is dispensed with.
On an earlier report, my dealer is here.
Yes.
I am reading, it is affirmed by the executive engineer that is showing the location of pipeline, that a portion of the land in question as involved in the present petition and a major portion has been utilized by the PWD Purva Medinipur.
This demarcation was done in your presence?
My presence, but not properly done. I am just now I have talked with my lord, with my client. However, my lord, I shall make my submission on the other date, my lord, if so.
Because 907 has not been utilized.
But 9.8 and 9.1 decimal and 6 decimal properly, completely has been utilized.
Other plots have been utilized. That your report says so.
Lord, your lordship will find. I'll place it on the next day. Lord, 1 decimal of, say, suppose plot number 908, 1 decimal is with the petitioner. Lord, this 1 decimal is still there. It has not been utilized. What has been utilized, the residual portion of the road, I think it's a national highway, the residual portion of the relay line, which is toward the road. There's a relay line cutting it after the acquisition. We have put it on the side which was acquired, not on the 1 decimal, which is of the petitioner. That I'll try to explain, and I'll also try to bring the total area of the plots and the part utilized, and I'll give it by 14 to my learned friend also, so he can take instructions.
We can reconcile.
Yes,
and we can
on earlier occasion, it was my lord, measurement was made in presence of the my lord, all concerned. Now thereafter a report was filed that a portion has been, major portion has been utilized. Now my learned friend appeared. My lord, he sought for direction for further demarcation. But maybe, but once it has been done within in presence of all concerned.
Please come back. Please.
Yes, my lord. I shall do it. Yes, and I also request my learned friend also to take the instruction.
Whatever data and measurement I will rely on 15th, I'll hand over to my learned friend by 14th.
My lord.
Yes, next man.
Item number 14.
I beg to appear on behalf of the National Highways Authority, my lord.
You are appearing for the National Highways?
National Highways Authority, my lord.
Well, in this matter, my lord, I am appearing for the petitioner. This is relating to, my lord, the apportionment of compensation, because the petitioner, if your lordship, also claiming compensation in the plot in question because it was the predecessor of the petition parties was the actual owner. Now the money has been paid, my lord, from the report it will appear, my lord, if it was filed. The money has been paid to one.
I am appearing for the private respondent.
Yes.
We have been paid.
Yes.
The entire money has been paid to us.
Now, my lord, can you consider what is?
You are co-sharers.
I am claiming co-shares. Yes.
Well, the ancestral property was settled in between the brothers. The portion we were enjoying, that has been taken over by the government. They used to reside elsewhere. Now, since possession was taken over from us, our names were recorded in the record of record. Since possession was taken over from us, we have been paid the cost. So, if they have any other agreement, they should go in civil suit. Petition cannot be made.
Yes. Well, the recorder is so far the little recorder does not confer in title over the necessary immovable property. There is a specific provision under the.
Learned counsel is on possession. He has not said title.
No, possession, but the compensation is does not only possession. My lord, can you consider? Here, my lord, I am claiming that yes, I am entitled to enter. I filed an application for apportionment under the provision. The National Highway Act, there is provision. That is the application your lordship find. That is at page P10, page 42.
You have asked for reference to the civil court.
Yes, because that the adjudication can be done only by the civil court.
Page?
Page 42. Our first application, my lord, page 33 is, my lord, the initial application which was filed. That is the legal notice. My lord, P10, my lord, will lordship find. This is the reference which I sought for.
H4.
3H4. Because if it is paid, my lord, that is the only authority, my lord, the 3H4 to adjudicate. I cannot establish my claim over the any other authority 7 except it is unless until it is referred under 3H4.
Let the civil court decide. Let this page 33 be considered by the authority and let the civil court decide.
For a minute, can you turn back to page 31?
Yes.
Page 31. Let's see from the order dated 31st October 2019. Everything will be clear. This is the finding of the authority. This observation was made after the representation was considered.
How did they decide title?
Yes.
Under what authority?
Maybe. But possession, our possession was admitted.
Possession, no. Only possession is not admitted.
That was the wrong.
Belongs to doesn't mean possession.
And now one can turn to page 31. Page 31.
I'm on page 31.
31 said the holding number which they are saying there is no existence of such holding number. It is the case of the Durgapur Municipal Corporation. P8. Next page. Because I don't want to disclose anything to that effect, my dear lordship, fine. In response to your letter.
They have decided title, which they
yes,
cannot-
everything.
That cannot be done. Title to be determined. He should, my learned friend should go to the civil court.
There is a
Title can be
provision
decided.
for
There is
he's
a-
asking for apportionment. If let it be referred to the civil
No,
court.
there is already apportionment. He stays 50 kilometers away.
Yeah.
He has got his portion. This was amicably.
Yes.
Brother.
Now, my lord, amicably settled. My lord,
Ancestral property was amicably settled between the brother. This is the portion.
and the sisters and the daughters will be out of position.
Let the
We
matter
have been enjoying for long.
let the matter be referred in terms of this letter 3H4. Let the court decide. There is a provision for reference and apportionment.
What about that?
The petitioners and the private respondents claim to be co-sharers in respect of the plot in question. So, admittedly, the plot has been acquired by the National Highways Authority of India and compensation paid to the private respondents for the same. Do you have anything to add, sir? National Highways,
I have no instruction, my lord. I have to take instruction.
you don't need further instruction. Let it be discussed.
Kindly, my lord, record only one sentence. My only one submission, Lord, kindly record. This was settled long before.
Well, what
Long
is the
ago,
settlement, my lord?
ancestral property was settled between the brothers long ago. The portion we were enjoying, that has been taken. But you will kindly record.
Well, that I am disputing, my lord, record that also. And there is no provision under the Act for partition without section 14 of the Original Land Reforms Act.
Paragraph, Learned Counsel for the private respondents submits that the plot was amicably settled between the parties long ago and the private respondents were in possession of the plot since then, for which compensation was paid to them. Paragraph, the contention of the private respondents is denied and disputed by the petitioners. Paragraph, the petitioners have submitted an application under section 3H within bracket 4 of the National Highways Act 1956 before the concerned authority for apportionment of compensation upon referring the matter to the learned district judge. Is it Purbo Bardhaman or Paschim Bardhaman? Paschim Bardhaman.
পশ্চিম বর্ধমান শুরু করুন।
Learned district judge, Paschim Bardhaman. Learned district judge, Paschim, Paschim Bardhaman. Stop. The application is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the application and refer the same to the learned district judge, Paschim Bardhaman, under section 3, capital H, within bracket 4 of the Act of 1956. Paragraph, learned counsel for the state respondents submits that who should refer?
The competent authority will refer, my lord. It was
Respondent number?
respondent number, my lord. 3. Because he is the authority who received and he has
Third
to,
respondent be directed
along with the
to
documents, he should refer the
consider
matter.
the application in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the third respondent to consider the application under section 3H4 of the Act of 1956 submitted by the petitioners on, what is the date of your application?
Date of the application, my lord. It was submitted on 15/6/2020. At the left, at the first page, page 33, left-hand side bottom.
On 15th June 2020.
Yes. এই 15/6/2020
1 month. It's only a reference.
Only reference, they have to forward all the documents and other
1
things.
month from the date of communication of this order. You need to be heard? No, not necessary.
4H3 is the provision, my lord, for ascertaining if there is a privacy dispute.
Or kindly give us a chance because we do not know what will happen.
Your chance will be before the district judge.
Civil judge.
The referring authority.
Grateful to lordship.
Disposed of which?
Grateful to lordship.
Grateful, my lord.
Next.
Item number 15.
You. We are applying for the state respondent.
They're supposed to file a report rather. Issue of compliance of the order. Get a copy then.
Have you received a copy?
Just now.
Where is this order of the earlier writ petition? 4th October 1996, page?
Yes, ma'am. Page 27, ma'am. 27 is the relevant part, the direction part. And in the report, they have said that due to non-availability of the sufficient quantum of vested land, they could not give us an alternative land.
This been complied with?
No, they could not. But they have said in their report, just now I've seen, paragraph page 4, ma'am, second paragraph.
They could not.
To patta holders endeavor was taken, but due to non-ability of sufficient.
That cannot be a grounds.
Of vested land free from encumbrances to that Mauja and vicinity, the undersigned informed the same. My lord, kindly see the last paragraph, my lord. Same page, my lord. Again, on 27/12/2019, a team was formed for searching out suitable vested land as per order of the Calcutta High Court. The requirements of vested land is about 7.5 acres to settle 137 ex-patta holders, considering 0.05 acres for each family, but there is no such huge quantum of land available. And as soon as my lord, land is available, they will get there.
So that may be after 50 years? As soon as is a very vague term. Why will the patta holders suffer?
Because it is not available at present, my lord.
To give them back the land that was originally allotted to them in that case, you have to comply with the order by any means, isn't it?
Yes, ma'am.
Or you face contempt.
Some time may be allowed to the authority council.
Yes.
Some more time may be.
How much more time? I'll grant you time, but you have to give the land. It's a 1996 order. In 2023, you cannot come up and say that there is no land. You took no steps since 1996. You cannot sit over an order of this court since 1996 and come back in 2023 and say that there is no land. Cannot be accepted at all.
Yes.
I'll give you another 2 months. After that, I'll issue contempt. Let your authority face the music. Report in the form of affidavit submitted on behalf of the 7th respondent is taken on record. Paragraph, learned counsel for the respondents submits that alternative accommodation could not be granted to the patta holders in compliance with the earlier order passed by this court on 4th October 1996 in civil order number 10179 within bracket W of 1996, since due to unavailability of the required land of about 7.5 acres. Stop. Paragraph. It is not acceptable that an order passed by this court in 1996 has not been complied with by the authority till date, and in 2023 the authority comes up with a plea that sufficient land is not available. Paragraph. As a last chance, comma, the concerned authority being the 7th respondent, 7th respondent herein is directed to comply with the order dated 4th October 1996 in civil order number so and so. Within, I'll give you 31st January.
My lord, some more time may be allowed, my lord. 4 months.
2 months, very well. 29th February. Within 29th February 2024, paragraph, let the matter appear under the same heading on 6th March 2024. No further accommodation will be granted. I make it very clear.
Until and unless the vested land is not.
The court will hear nothing. What were you doing since 1996? You are already under contempt. Isn't it?
137.
Do whatever you can, but give them alternative accommodation.
Item number 16.
This matter I beg to appear for the petitioner.
My lord, I beg to appear on behalf of the National Highways Authority.
My lord, kindly take up the matter after vacation. My lord, state and as well as my lord, National Highways Authority has filed their report. My lord, I have to file my exception. My lord, it has not been affirmed yet. My lord, yes, my lord, not ready. My lord, kindly take up.
Learned counsel for the petitioners seeks extension of time to use an exception to the reports submitted on behalf of the respondents. Paragraph, let the matter appear under the same heading on 18th January.
My lord, grateful.
Grateful, my lord.
Item number 17.
On behalf of the petitioner in this matter, Your Lordship, kindly keep this matter after vacation because exception is ready, Your Lordship. Today my client has come and affirmed me. Kindly keep this matter on after vacation.
We are appearing on behalf of the respondents in this matter. Pursuant to lawsuit direction, we have filed the report.
Please come back after vacation in that.
Yes.
After namtai debe.
Mr. Dev, appearing for the state. Have you submitted your report? I do not find it.
Milord, the original was.
You had asked for extension of time. It is not record.
Milord,
Coming now.
we have missed the original one. That's why last occasion we said that we make it Xerox and serve it. Also, can you excuse me on that?
You have to swear a further affidavit. This is a copy.
আছে
I'll grant you to affirm the report again. I'll grant you liberty. You have to reaffirm. Mr. Dey, your report. Not ready? On prayer of the WBSTL, liberty is granted to reaffirm the report in the form of affidavit. Since, according to learned counsel, the original report is misplaced.
Election report.
Report in the form of affidavit. Paragraph. Learned counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph. Let the matter appear under the same heading on 19th January.
19th January.
Well, the one thing Milord, I could not follow. Petitioner asked for adjournment.
Yes.
And we, the respondents company, filed the report.
Where is
And on the basis of the report, we have to file exception.
I'm not saying that. Just I'm saying we are the respondents who have been entrusted to file it.
Yes.
I'm saying that.
And I've granted liberty to reaffirm the report because the original is misplaced.
After 19th.
Next.
Next hearing date we will file the report here in the court.
19th.
19th January.
Item number 18.
I appear for the petitioner. Lordship may take up Lordship's last order, where the third respondent, the district judge, was directed to furnish sanction with complete statement of the lapsed deposit. Concerned with.
Yes, has that been done?
Lordship, we have not received any intimation yet.
Was supposed to go before the principal secretary. Yes.
On the basis of the report of the this was sent to the principal secretary.
Yes.
Your lordship kindly pass on order to approve this. All that 2,000 estimates.
Maybe we get a copy of this. We may have to take an exception to this, because this is not the entirety of the sums which are due. There are two accounts, which I can see only one account here. Lordship, দুটো sir deposit হয়েছিল. Lordship keeps it on the reopening. Lordship will not pass any order as of yet. Keeps it on the reopening. Let me consider, my lord, this report.
This is not the entire amount.
This is not the entire amount. Now, there are two deposits.
In the name of Sushil Modi. No, joint.
No, Sushil Modi. Yeah, actually, সেইটা আছে। Paragraph 15 আপনি বলছেন।
Come back and.
Lordship keeps it in the reopening, my lord. 1 week after the reopening, Lordship, we shall file an affidavit to this. Yes, I have no problem for that.
It's the report. This is only annexure A, and you can place this before the court like this.
And this is already sent to the principal secretary.
Yes, but this should be on affidavit, isn't it? Or at least a forwarding report.
No.
It is only an annexure.
Lordship, that is also true.
It is submitted on behalf of the state respondents that the third respondent has furnished sanction with complete statement of the lab's deposit before the Principal Secretary, Judicial Department, Government of West Bengal, as directed by this court. Paragraph learned counsel for the petitioners seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading on 18 January. Next.
Can it be, Lordship, 1 week after vacation, my lord?
Come back with this. Next.
Item number 19.
My lord, item number 19, I appear on behalf of the petitioner. Your lordship recalls this is that matter. Lordship.
Yes.
Your lordship recalls this is that matter, your lordship, where the respondent number 4, my lord, subsequently purchased land which originally belonged to Indian Oxygen Limited. My lord, there was an order of exemption. My lord, admittedly, the respondent number 4 ceased its operations in 2015. Thereafter, my lord, we had sent a representation to the Urban Land Ceiling Authority saying that the land should be deemed to have been vested. My lord, aggrieved by that order which had been passed, my lord, we had preferred an appeal before the special secretary. Now, your lordship, we had shown your lordship on the last occasion that, my lord, the authority had called for some documents, my lord, which were, my lord, not there when the matter had been disposed of. My lord, Mr. Obrojit Mitro is leading me. My lord, the matter was being argued by him. It was argued substantially. My lord, he is on his legs. My lord, we only want to rely on
This
2-3
was a
judgments.
prelude, my lord, for a prayer for adjournment. My lord, because of the relationship we share, my lord, I cannot stand in the way. But, my lord, the issue before your lordship, my lord, squarely covered by a division bench judgment recently passed between the two parties. My lord, it has come back to my lord's mind. Kindly, my lord, peremptorily fix a date and time. My lord, clients are castigating us. My lord, Mr. Basu is ready.
Your lordship will kindly keep the matter tomorrow, my lord. We'll come and finish our argument. 10 minutes লাগবে. My lord, we'll take 10 minutes, my lord.
On prayer of petitioners, the matter is adjourned.
Kindly fix a peremptory date, my lord.
Let the matter appear under the same heading on 8th January.
Yes. Kindly, my lord, indicate that
Lordship
this date
fairly
is
at the top,
peremptory.
my lord, fairly.
Also, you had sought adjournment.
Lordship, I have.
My
Next
lord,
day we'll
one
argue.
liner to save our face before the clients. My lord, if they come and pray for an adjournment, my lord, we will not oppose. But
One order of the court which is not peremptory or mandatory.
my lord, this is
That's what.
my lord, difficult to make the client understand. My lord, a one liner, my lord, will save our face before the vacation.
Lordship kindly directs the matter to appear fairly at the top, my lord. On 8. My lord, we'll argue, my lord.
Very funny.
My lord, we'll argue, my lord. My lord, on 8. My lord, 8, my lord.
Consider.
Great.
Next one. 2021 matter is appear February. This is 12 o'clock matter.
Well, item number 20 was the next matter.
12 o'clock, I believe there's a matter fixed.
The Lordship had directed the state to file a report in my earlier matter, my lord. The report has been filed, my lord. It has been given to us. And I would like to show from the report itself. My lord, may I take 2 minutes of your lordship's time?
There's a specially fixed matter at 12. If it's not there, I'll just take this matter. Give me a minute, please. Yes, Bharatata Rakhanta. Please call the 12 o'clock matter.
Yes, your lordship.
71.
I am for the private respondent, your lordship.
তাহলে কি আমরা রিলিজ করে দেব?
এটার পরেই হবে।
71, anyone for the
Calling.
Yes, petition is.
My learned senior friend was waiting. If my learned senior
I may
friend
not-
is taken up for 2 minutes.
Yes, your lordship. I have no difficulty, your lordship.
জানি না স্টেটও নেই।
Item number 20.
anyone for the respondents in 20?
This matter will come back to your lordship, my lord. We have challenged an order of resumption of the plot of land under a lease. This was under a lease, and the ground in the show cause notice was that I had not utilized made construction on the plot within 3 years. But I had shown documents before the authority, as also in the writ petition, that there was a manufacturing activity running, central sales tax documents, challans, everything was shown.
I can recall, yes.
Yes. And thereafter, my lord, I had abandoned that. I had applied for change of permission, for change of user to set up an IT industry. That application was kept pending. So my factory was closed, but within 3 years, it had already started running. Then when my factory was closed, they gave the show cause proceedings. But I replied to that show cause proceedings. But in the order, they take a different ground. They say that I went and inspect and I found that it is lying unutilized. But that was not the condition which they alleged that I had violated. Your lordship put the query to them to find out whether I had a sanction plan in respect of the earlier factory. So they had given a report. If your lordship sees first few,
find that way today. Respondents are not there.
I would only want to show your lordship only one paragraph.
Mr. Mahato is appearing.
Yes, Mr. Mahato was appearing.
Not there today. Mr. Mahato's junior friend is also not there.
This report will have to, I indicate to your lordship why I am saying this. They have referred it to Novodigonto Industrial Township Authority to find out about the plan. I find from the act and the rules that this authority came into existence after 2006.
Oh.
So they would not
be applicable. Yes.
They would not have the documents relating to the sanction and all. That is the only point I would have taken if they were.
In absence of respondents, it's difficult.
Very well, my dear lordship.
They also sought extension of time to submit
So
the
they have-
report. Have you
they
received?
have-
Yes, I have.
That is not a
Oh, that is
Formal.
that is a copy I have given to your lordship, but that's not the formal copy.
it's your copy.
Yes,
Yes.
ma'am.
The interim order is till 15 January, so let's
Yes.
fix a date prior to that.
Well,
None appears for the respondents. No accommodation is sought. Paragraph, let the matter appear under the. You want to use an exception?
yes, in the meantime, since there is I'm getting a time, let me use an exception, my lord. It will be on record then.
Liberty is already granted to you. For using an exception.
Yes.
Let the matter appear under the.
In the meantime, I will file the exception.
When? 11 January?
Yes. Will your lordship just give me that liberty to file an exception in the
That's
meantime?
granted on.
Very good. Very good. Obliged.
Yes, your lordship.
I appear for the.
Your lordship, for the private respondent, my only little submission is left.
Yes.
Your lordship, kindly 71.
Oh, 71. 21.
Before my learned friend starts, I just will indicate his affidavit. He's a very good Samaritan. Who is a social reformer and wants that no enemy property is owned by any private individual. But the case that I could make out in my writ petition is not as well as he has made out for me in his own affidavit. Kindly have a look at his affidavit.
Yes.
I have nothing to submit.
And I will only rely upon my affidavit, your lordship.
Give them.
Page 2, para 4.
You are for 13. Respondent
Yes.
for 13.
Yes, your lordship.
Who has allegedly lost a complaint through email to the custodian, and custodian has taken cognizance of that
For what?
for this enemy property, saying that there are enemy properties at 47 Moteshwar Tala Road, which has.
So they are the custodians.
So
They must-
he has triggered this proceeding. The paper publication under challenge is triggered by him, and he has the courage to come to your lordship.
The enemy
Yes,
property?
and my lord has seen the rules, statutory rules.
Your lordship, it is a when I came to knowledge that some illegality is there, I raise my voice.
Social reformer.
How are you concerned? Do you have any share in the property?
No. I have no touch in that property. I have no relation. I am the social person, and I used to raise my voice before this court and in NGT also.
Your parties.
Pardon, your lordship.
Public litigation from your side.
No. I have no personal interest. This can be transferred to public interest litigation also. Yes, because the grievance is relating to the nation. The authority concerned is not taking appropriate steps.
Why don't you take appropriate steps, sir?
Yes, your lordship, kindly grant me that liberty. I will definitely file PIL.
Liberty is necessary.
as it is already proceeding, that is the difficulty. So it will be contradictory with this petition as well as PIL. এই কপি দিয়ে দিয়েছি তো এফিডেভিট অপোজিশন কপি দেওয়া আছে
দিদি সাপোর্টিং এফিডেভিট দিয়েছে রিটেন আমাদের
হ্যাঁ কপি দেওয়া হয়েছে তো তাহলে আরেকটা তাহলে কপি আমি দিয়ে দেবো আজকে জেরক্স করে
Yes, any further submission from?
Yes, Your Lordship, in opposition, paragraph 4, I am relying upon that in prima facie appears that enemy property comprised at holding 47 Moistotara Road is being transferred by the Chinese person against which the deponent lodged a complaint with the custodian of the enemy property of India. Seeking India, Ministry of Home Affairs, Government of India, among others, inter alia requesting seeking the matter be referred to the CBI or ED to cause deep root investigation in the matter and register FIR, aiming to protect the sovereignty of the country and stopping the means of money laundering in West Bengal that has been causing huge financial damage to our country by foreign citizens joining hands with the state officials. My grievance is that until Your Lordship, how if
Also ask for CBI ED for evicting a tenant.
but it is not the tenancy dispute, Your Lordship.
I understand, sir. Yes, continue.
And seventh paragraph, Your Lordship, next page. That CEPI is only responsible for identifying their 8 properties with distinct DAG number as per land records, which they surreptitiously dispensed with but required to be properly investigated by an investigating agency. It is their duty. Who is the custodian? Your Lordship, when I raise my voice any illegal activity, the question arises.
Such a voice before a court having determination under group 1.
Till now not, but in PIL and NGT I hear.
Isn't it? So please, let us deal with the matter. Judgment be reserved.
As Your Lordship, please.
Take necessary steps before the appropriate court.
I'm deeply obliged, Your Lordship. As Your Lordship, please. Kindly consider my opposition once. Kindly, will Lord excuse our.
At all, sir.
As Your Lordship, Kindly please. do. As Your Lordship, please. Milord, kindly, Milord, excuse our excitement. Milord, my learned junior's excitement also. Kindly take page 4 of his affidavit. Well said, entertaining. Only one sentence at that page 4, paragraph 9, first sentence.
No. Public notice is vague.
He is also saying that.
Yes. You're admitting this.
Yes,
He is
the
submitting petition.
yes. In respect of their activity, whether they are being the custodian, whether trying to protect the enemy. Yes. This is true to his knowledge.
Yes, Your Lordship, because being the custodian of that property, what steps they have taken?
He's saying hand in gloves. Yes, necessary order will be passed.
Deeply obliged, Your
Grateful to your Lordship, Milord, so grateful.
Reserved.
Deeply obliged.
Milord, my learned juniors are saying that, Milord, because of this litigation, Milord, banks have, Milord, stopped, Milord, giving us loan. And, Milord, we are not being able, Milord, to proceed with.
You're not expecting an order prior to the next one.
Baron ko.
That was Mr. Kormukar's.
No, Milord, not at all. Not at all. Milord, grateful, Milord, for the patient hearing. Grateful.
Bank and all that submission was leading to that.
Absolutely, yes. Kindly impose, Milord, cost on him personally for this. Grateful, Milord. Great.
You can do that personally. There's lunch on him.
Yes. Milord, this order would be implemented. Grateful.
Arguments concluded, judgment reserved.
Grateful.
Yes, we'll come back to 21.
Let's wait.
Come back to 26. 21. Yes. What are the
উনি করেছেন Yes,
One.
21.
21 and 22 both are anomalous matter, your lordship. Yes.
Have you served the?
Yes, yes, I have served.
Yes, sir.
Yes, this is my evidence. Lordship, kindly come.
What is appearing?
Yes, my lord, but the answering respondent mainly Mr. Talukra.
Yes, your lordship, kindly come to first order dated 22nd February. 22nd February.
Yes, sir, 27.
Nah, yes.
It's a lease or a sale. That is the
Yes.
question.
Lord, therefore, I have filed this affidavit. Kindly come to page 11th of April 2023.
My lord, on the last
So Mr.
occasion,
Malhotra wanted to take instruction.
yes, on the last occasion, my learned friend filed a second supplementary affidavit.
Yes, that is a person to.
And in that supplementary affidavit, number of sale deeds have been
Yes,
annexed.
person to direction by.
My lord, I need to respond to that, my lord.
Well, every time they are saying there is no other deed. When I
No,
processed
when you are coming with some documents, the respondent must be given an opportunity to
that is
respond.
the deed they have been used.
Because in earlier supplementary affidavit he has annexed, we have replied, we have responded.
Where is the second supplementary?
Second supplementary affidavit filed on 5th October.
No, there is no such affidavit. Was the only one affidavit.
No, 5th October.
23.
5th October, one supplementary affidavit filed.
They have received it.
No, this
Yes,
one.
on
Earlier,
5th of October.
earlier he had filed another supplementary affidavit, which we have responded.
No,
Which Millard, we
what my learned friend submit, I don't know.
কি বলছো এই যে
দেখো না তুমি।
that recorded
That is only supplementary after the on direction of the honorable court.
no before that you have
That is the exception. Kindly see it.
what he was saying. This is your affidavit.
Yes.
Lordship, kindly
5th
5th April he has filed one supplementary affidavit.
And the next one is 12.
Next one is next one he has bulky one.
Yes, that is the.
He has filed it on 5th October.
But that is the.
Should I not respond to that? You will not give me any opportunity to respond. Then do it.
This is
But
all-
service has been made on 5th of October.
Yes.
I have served the copy of the supplementary, last supplementary on 5th of October.
5th of October you have filed, and there is
And
no
also served upon you.
there is no direction. There is no direction since service was not complete. Lordship, kindly have a look 5th October's order.
Here is the 5th October supplementary.
See, 5th October, it is affirmed on, my lord. It is affirmed on 3rd August. Filed in 5th October. I have been served with a copy on that day itself. Lordship, kindly have a look the 5th October order.
দাদা আমাকে একটা সাপ্লিমেন্টারি কপি দেন নট আ সিঙ্গেল কপি আমি জানিও না এই সাপ্লিমেন্টারি
That has been recorded. The service upon the office of the learned government pleader is not complete. That is why the matter was adjourned. And he has not given any copy to my learned friend also.
But that
the policy, the policy, we have no clash. What we are, my lord, taking resort to, that is the policy of the government. There is no clash, clashing of interest.
Have you served the government? He is
No,
also part-
not what my learned friend is saying.
Please serve.
And I need to, my lord, respond to that. My lord, identical issue was before the Supreme Court. That is very policy. There the Supreme Court did not negate that.
Petitioner's case is otherwise.
Oth-
Petitioner says you are referring to the policy, but
Yes.
even after the policy, you have executed sale
Yes.
deeds. These are the deeds.
Yes.
These are all sale deeds executed by the KMDA after the policy. So if you could do this, you have to execute it in favor of the petitioner also.
I understand, my lord. I understand. After this policy of 2012, my lord, the KMD had adopted this policy in 2016. So all these deeds were executed
Between 12 to 16.
In 2020 also executed it.
So where is the document showing that the KMD adopted the policy?
Yes, yes, that
Yeah.
policy I need to, my lord, annex. Because 2016 policy at
My
considered by this.
allotment is 2006. Whether the 2016 policy is applicable in my case or not.
You may question that, I must
But that
disclose
is
that.
not applicable. That
Let him come back with the exception to this.
Yes.
And let me have the copy of the both the supplementary affidavits.
difficulties are every time change the state advocate, that is I have to serve again and again. আগের লয়ারকে সার্ভিস হয়েছিল তখন সে তো চলে গেছে আবার তোমাকে নতুন করে সার্ভিস করতে হলো আর ক্ষতি কি আছে তুমি কি করে বুঝবে?
The second supplementary could not have been served to the earlier advocate because it was filed on the.
Yes, yes. The service was not complete.
In the month of May, perhaps.
No, August.
August.
3rd
Yes.
August.
There are anomalies. The seal says May, the
Yes.
affidavit says
Been
August.
through 3rd August.
Seal, there is no pen. It's-
Copy served on 5th October, filed on 5th October.
Please serve copies.
Yes, yes, I will serve again. No problem.
Only I will disclose that policy and explain the period in between.
Service. তারপরে learned counsel for the KMDA
ধরে
seeks to use an exception to the second supplementary report submitted on behalf of the petitioners. Paragraph, let the matter appear under the same heading on 22nd January.
My lord, one thing your lordship already passed. They have said that 2016 onwards they have adopted the policy, but in 2020 they again said it has been.
So another supplementary
Yes.
affidavit you are.
Yes, that is annexed to the exception. Kindly go through it.
In item 22, I am appearing on behalf of the state respondent, my lord.
Affidavit.
আমাদেরও কপি দেয়নি কোনো
তাই?
শিষ্য আর
কোন affidavit use করো?
আচ্ছা
21, 22 are same and identical.
21, 22.
Same and identical.
Same answer.
22, I am appearing on behalf of the state respondent.
Matter will appear below.
22nd January.
কেউই তো আসেনি আপনাদের।
Next.
আছে ওরা আছে কোর্টে আছে
কোথায় আছে?
আমি কপি
Number 23.
मतलब 23 मतलब paying for not this मतलब kindly मतलब fix the matter after vacation. Mr. Udaran or better appearing for the petition.
Prayer of the
I am appearing for the WPHCDCA.
on prayer of the petitioner, the matter is adjourned. Governor. A paragraph, let the matter appear under the same heading on 24th January.
23 minutes.
24th January.
20.
Petition responding.
Oh, I'm sorry. নামটা দিয়ে দাও।
Next.
Item number 24.
24, my lord, Mr. Kajal Roy is appearing on behalf of the petitioner, my lord. I'm praying for not today.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 25th January. Next.
Item number 25.
25, my lord, I am appearing for Advocate Arindam Das. He could not come to the court. Kindly adjourn this matter.
Same order, Raju. 25th January. On prayer of the petitioner. Next.
Item number 26.
I for the petitioner, my lord. My lord. The state has, my lord, filed, my lord, the compliance report and
I am appearing on behalf of the state respondent.
affidavit. But in the affidavit, my lord, they are very, my lord, cleverly, my lord, avoided the main issue. Main issue, my lord, they have, my lord, acquired my 0.45 acres of land. Thereafter, again, my lord, they have, my lord, forcibly, my lord, occupied 84 meters length and my lord, 4.8 meters width, my lord, road, my lord. That has not been acquired, no compensation has been paid. My lord, kindly see the report they have submitted. They have avoided that issue, main issue.
For 0.45 acres, you have received compensation.
Yes, my lord.
There is no
No,
dispute.
no
with regard to
dispute.
that part.
No, not dispute. But my lord, regarding my lord, my lord,
That was never
additional land.
disclosed in the writ petition, my lord. That was never disclosed by the writ petitioner in the writ petition, my lord.
Yes, kindly see the writ petition.
And in the year 2012,
And it is the matter of my lord, not to have.
they have received the entire compensation money.
Thereafter, what happened? Kindly see. Let them.
That document
They-
was
they are
never
not-
annexed in this writ application, my lord.
Well, let them disclose that they have not occupied my access.
Stated in the writ petition that beyond 0.4.
Yes, my lord. Yes, right. Yes, I am saying.
Also, you have stated that you are not happy with the compensation.
Yes. That is I am happy, my lord. But my lord, the excess land which has been.
Where is it stated in the
I'm coming, my lord.
Please show me.
Kindly paragraph 19. Paragraph 19, 20. I have stated.
Oh, this is 8.17 decimals.
My lord, length, my lord, is my lord 84 meters and 4.300, my lord.
Where is that
Page.
stated?
84 meters.
My lord, page 19 and 20, kindly page, paragraph 20, page 11.
Oh, 84 meters and 4.300
Yes,
meters.
yes, my lord. Let them disclose that they have not, my lord, taken their land. I will take possession of their land without holding any, my lord, proceeding.
And kindly look into my.
Have you dealt with this part in your report?
No, nowhere.
No, my lord.
State response.
Yes.
No.
Then that is the issue.
My respected submission before your lordship that only in respect of the plot number 125, the land was acquired.
That is admitted. 0.45 acres in plot number 125 acquired and compensation paid, that is admitted.
And we have no grievance.
The dispute
that.
is regarding a little more portion
Yes.
which you have utilized without acquiring. Have you dealt with that in your report?
No, that was not dealt with, my lord.
Subject matter.
But my lord, my instruction is the accepting this plot of this area. Only 0.45 acres of land was acquired, my lord.
Acquired.
Yes, my lord.
This portion is not acquired, it is utilized. There is difference between acquisition and utilization, isn't it? You have utilized without acquiring. That is the case. Where have you dealt with
No, that portion was not dealt with, my lord.
what you have dealt with is admitted.
Yes, my lord.
45 acres you acquired,
Yes.
compensation paid, that is admitted. That is not the question, the subject matter of the petition at all. The subject matter is the excess portion that you have utilized without acquiring.
You have not uttered, my lord, single word regarding that.
Then my lord,
Secretary has not followed it at all.
kindly give some time, my lord. I will deal with, my lord.
Please take instructions on this.
Yes.
The acquired part, no dispute at all.
But that document was never annexed in this treaty application, my lord.
How? Is there any document was served upon me that we are going to construct the road?
There cannot be any document for forcible encroachment, isn't it? The petitioners complain that besides
Nah.
acquiring 0.45 acres of land in this is RS Dag number 125.
125, my lord.
120 RS Dag number 125, comma.
124 was
The
not involved.
respondent-
Yes.
The respondents have utilized .84 meters and 4.300 meters of the petitioner's apostrophe land for
And
construction.
kindly mention the plot number, my lord.
The same plot.
125.
125.
Recorded all.
But in the prayer, he mentioned, my lord, 124 and 125. But 124 was never
Yes,
not involved, my lord. Only 125.
25.
For construction of a road without acquiring the same by due process of law. The report submitted on behalf of the respondents is silent with regard to such utilization. Paragraph learned counsel for the respondents seeks to take instructions in this regard. Paragraph let the matter appear under the same heading on 24th January.
Yes. मुझसे देखी तो उसको हो गया
Item number
my
27.
lord. Number
Lordship, I'm appealing for the Jila Porishad respondent.
And for the state, your lordship.
24 January.
Who is appealing for the petitioner?
My lord.
Yes.
My lord, advocate on record, Arindam Das could not come to the court. His father-in-law has died.
27, 20, and 29 all are identical matter. I am appearing on.
Pair of the petitioners, the matter is
না, না,
adjourned.
বিনা, তাই তো?
Paragraph let the matter appear under the same heading on 25th January.
Deeply
27, 28, 29.
29 identical issue.
Yes. Oh, mention matters.
অনুপ দাশগুপ্ত ইউনিয়ন অফ ইন্ডিয়া আপনি একা অনুপ দাশগুপ্ত ANUP অনুপ দাশগুপ্ত ইউনিয়ন অফ ইন্ডিয়া অনুপ দাশগুপ্ত
Item number 529.
ইউনিয়ন অফ একটা দিন দিয়ে দিন আমরা দিয়ে দিই
Yes.
লাস্ট কত কবে আসবে 25
529.
I'm for the state this one.
Lordship, Mr. Pankaj Haldar is appearing for the petitioner. He is at currently courtroom number 24. So Lordship, kindly make it short passover. He's coming.
After vacation. See, mention matters. On prayer of the petitioner, the matter is adjourned. Paragraph let the matter appear under the same heading on 25th January. Next.
Item number 530. 530.
Item number 531 and 530 relating to the same plot. But 531 is respect of the same plot and 530 is the same plot. My lord, in the respect of 530, my lord, I have not made the party.
Right? What is happening in this matter? I lodge a complaint to the extent that the petitioner, the private respondent, is encroaching the government PWD land. My lord, and passed an order to initiate the proceedings under section 10 of the West Bengal Highway Act. My lord, in the meantime, my lord, the order was passed. He filed an application for recalling of your lordship's order. That is can 1, my lord. The matter was mentioned without serving any notice to me. My lord, can 1. My lord, in thereafter, my lord, on the 5:30, my lord, this in respect of same plot, he filed another writ petition alleging that this plot is a royalty plot. My lord, in the meantime, what has happened? My lord, in respect of my lord 5:30 on the same plot, my lord already declared as the my lord, he is unauthorized occupier, and proceeding was concluded, and he has declared my lord as unauthorized occupier. Now 10:3 was my lord over. My lord, then my lord, he filed a recalling application, and this recalling application, your lordship was in heard this matter on 3rd of February 2023 and directed me to file a report, to file a opposition. My opposition is ready. I am the my lord, in respect of can application, I am the respondent. On 856, I am the petitioner, lead petitioner. Now 5:30 is the the person who has where I was not made party, but in respect to the same plot.
Both are running analogously. 5:31 to the
5:30, my lord, my lord.
No notice was served upon me before mentioning.
Notice was served upon.
No notice was served upon before mentioning also.
Due to change of the my lord, the panel, my lord, it has learned advocate, my lord, Srikanta Pal appeared, my lord.
Yes, petitioner in 5:30.
Yes, lordship. 5:30 led by Mr. Pankaj Haldar. So the fact of the case.
5:30, I am the lead
Have you
petitioner.
been appointed in 5:30?
I'm 5:30, my lord, but brief is not with brief.
5:31 or 5:30? 5:30.
5:31.
5:30, you have to serve a fresh notice because the panel has changed.
All right, lordship.
5:31 आप एक्चुअली से दे भी आपको डिवीजन में नहीं
Since there has been a change.
In this matter, I appear on behalf of the applicant. Earlier matter, that is the item number
5:30 and 31 are taken up together.
Today.
In 5:30, a fresh notice upon the state has to be issued because there has been a change of panel and no one is appearing.
Lordship.
Yes, because the previous advocates are no longer there in the panel. So both will be taken up together.
Today.
Together, not
Together, my lord. This is now by at my instance, the matter is it is the extremely urgent.
No notice was the
Admittedly, I sir, my lord, sent the notice to my learned senior friend by WhatsApp. It is admitted, but the fact.
service acceptable.
No, that is not, my lord. But your lordship can consider only exceptional circumstances.
You served.
My lord, I'm learned friend.
He is not appointed at all in this matter.
No, my lord. He appeared.
5:30 is not appointed.
In earlier occasion, it is a matter. The petitioner has not supplied the writ petition. In spite of the lordship.
5:30, 5:30. Mr. Tenhuka was there.
My lord,
No longer in the panel, so to serve afresh.
No, my
There has
Bandopad,
been a
Mr.
change.
Bandopad, lordship has engaged Mr. Bandopad. My lord, the writ petition has to be served my learned friends. I have served the copy of the case.
Friends, you have to serve the government leader's office.
Well, this is not the writ petition. Next item, that is 31. I am not the writ petition. He is the writ petition. 30, I will serve.
30, I'm talking
I-
about 31 at all.
Lordship, 30, I will serve.
And since they're connected, they'll be taken up on the same date.
My lord, date, my lord.
After vacation, obviously.
My lord, the problem is this, my lords. That is the third round of litigation. My lord, only one the exception.
Maybe. Please come.
My lord, because of that.
Under challenge. 10-3 order has been passed already, isn't it?
So no, that order cannot be simultaneously parallel proceeding. That is the hell, my lord Justice Joyson Gupta. Because of that, my lord, if your lordship kindly order of the my lord Justice Joyson Gupta, because of that, a proceeding has been initiated, counter blast proceeding has been initiated 2015. My lord Justice Debanshu Bosak was pleased to stay of operation of that proceeding. Now the government has come with the report before the my lord Justice Sanjeev Banerjee when the matter was taken up. They have not confirmed whether the land is vested in the name of the state or not. Subsequently, I got the report and the acquisition cancellation proceeding. The land is not acquired by the government. That is the challenge since 2015.
Come back. Since there has been a change of learned counsels in the state panel, the petitioner petitioners are directed to serve the office of the learned government pleader afresh and file affidavit of service on the adjourned date. Paragraph, let these matters appear under the same heading, under the heading motion on 9 January, immediately after.
And my lord, this the order of the my lord Justice Joy Sengupta has to be carried out because of that there was a direction to file a
Nothing
report.
is on the record, my lord.
My lord, that is the very order of.
My lord, your lordship kindly see the 531.
Learned counsel for the state praise for taking appropriate instructions. The learned
As per direction of the my lord Justice Sengupta.
yes, learned counsel is not there at all. They serve and come.
So no, my lord, that report I will serve the order also.
Next.
Yes. Yes. পরেরটা not today নিচ্ছিস তো
30 and 31 both.
31.
Covered by cover not.
Not. Yes.
Item number 532.
My lord, 532, I beg to appear on behalf of the petitioner. My lord, kindly recollect in this matter, the issue, my lord, regarding the, my lord, opening a poultry farm. And the embankment of a, my lord, pond. They are supposed to give a report today.
Yes.
As a last chance.
Wanted to take further instructions.
A big report. So I have to go through it.
এইটা ভুলভাল ছিল ভাই তো
My lord, poultry farm is very small, but the report is very big.
This is not the case of the setup of a poultry farm. The matter arises out of the result of the order passed by the Honorable Division Bench in a public interest litigation. One public interest litigation was moved by a private respondent alleging the pond is filling up by the petitioners, my lord. Accordingly, the district magistrate might have taken a hearing and passed the impugned order. That is under challenge.
My lord, that is not, my lord, completely, my lord, incorrect statement.
Incorrect.
My lord, kindly go through the, my lord, order passed by the district magistrate.
Says that he is trying to start the poultry farm in his own land. Not
It is not that case, my lord. He is setting up a, my lord, the poultry farm in the pond as recorded in the, my lord, the ROR and also in the record. Poultry, pukur, my lord, is not, pond is not, my lord, permitted to fill up by any.
My lord, that is the third case he is trying to make out here.
We have
Kindly
come
go
with
through the, my lord, dear. It is neither the case of the state even
Yes,
before
yes,
the
it's the case.
district magistrate. May I come back after going through it? I'll give a short date, my lord.
You use an exception to this.
Exception, if yes. Because certain things has been, my lord.
Submitted on behalf of the state respondents is taken on record. Paragraph, learned counsel for the petitioner seeks to you, petitioners seeks to use an exception to the report. Affidavit not the report submitted. Paragraph, let the matter appear under the same heading on 15 January.
Right. 15 January. Right. I know that you are here.
Item number 533.
33, I am for the added respondent. My lord, I have a preliminary objection to the maintainability of this application. Because
I appear for the petition.
because the person who filed this writ application is not interested with the plot of land. And she is not linked with the plot of land, disputed plot of land.
Disputed.
This is my preliminary objection,
My
and
lord,
because she has no local standard to file this writ application.
My lord,
Although there is an allegation for illegal and unauthorized construction.
A civil dispute is pending, a civil suit is pending.
No.
Civil dispute pending, that is related to the, not this petitioner, the original owner.
My lord,
And we are the recorded owner of the PWD land. The PWD authority leased us the land for long-term lease. In my application or addition of party, I have annexed that document.
My lord,
That application has already.
Submitted for the state.
state cares.
I think Ratul Vishwas somebody was appeared.
Private respondents. Well, I have
Private.
got the private respondent number 9 and 10. 9 and 10. Well, these two respondents, they are wrongly added as a party respondent. Well, they don't have any relation.
8, 9.
Allegations of the district about the petition. Well, he is appealing for the subsequent added respondent. But maybe there is a dispute between him and the petitioner. But these two respondents, they are wrongly.
My lord,
State response of
State is not there.
who is appealing for the state?
State কে ছিল? Your lordship, your lordship kindly come to page 17 of my read.
Ms. Shweta Mukherjee and Mr. Ratul Das, are they still in the panel?
They are in the panel আছে Ratul Das আছে he is in panel.
Yes,
He is in panel.
they are in the panel.
Yes, yes.
Shweta Mukherjee and Ratul Das.
Shweta Mukherjee
আছে
State.
তেইশে ওই কদিন আগে অ্যাপিয়ার নতুন এসছে নতুন এসছে I have given the notice to her. She has received the notice also. After mentioning, I have received. My lord, given the notice. My lord, page 17 in my writ petition.
I cannot hear it in absence of the respondents, isn't it?
That's very innocuous prayer. My lord, the authority will decide. If he is on earth, he will be there. If he is not, he will be removed. This is the land of the government. PWD acquired the land. Page 17, your lordship kindly sees. This is the crux of the matter.
Yes,
I sought for the information, and information has been supplied. Enclosing, please find a copy of the application received such and such. The road taken over by this office in the month of July 2014. PWD taken over the road in 2014 after due process of acquisition. As per letter number such and such, government. On verifying the office record, it is found no such lease has been given to the above noted plots. For the instant case from this end, this is the matter. The PWD land cannot be leased out. That is the law. In any event, my lord, they are claiming they have been given the lease. The authority will decide whether encroachment is there or if he is residing validly. Let that be decided by the authority.
Consideration.
Yes, absolutely.
Let that be done without.
Yes. He will produce his lease.
that can be done.
Yes.
That can, but the preliminary objection, the writ petition, who is that person? He is claimed to be the second wife of the petition, original landowner. The first wife is living with his son. This petitioner has no connection with the disputed.
Yes, yes.
My lord, he is a Hindu. She is ultimately Hindu. Cannot be second wife claimed to be a owner of the.
These are the disputed facts. Yes.
Not going to first wife and second wife.
Yes, yes, yes.
That's right.
And what is your claim against the private respondents?
In front of my property, they are residing with Pakka structure, encroaching the government land, that is PWD land. That has to be removed. If they are actually having the lease deed or have the title over the land, they will be there. If they do not have, then they will be removed. In terms of this, my lord, page 17, it is clear that there was no lease. This is the authority, Executive Engineer, Nadia Highway Division. He is writing to us saying that this land never been leased out.
My lord,
Therefore, let him decide it.
kindly come to page 11 of my application for addition of party. I have annexed all the record of rights, wherefrom it reveals that the PWD leased out the property to the owner who was to the occupier who was the existing owner.
কোথায় PWD?
পশ্চিমবঙ্গ সরকারের পক্ষ থেকে PWD. My lord, page 11 onwards. Here the relevant portion is, my lord, page 22. Relevant plot number 4077. My lord, Anil Kumar Pramod Ranjan Mondol, page 22.
Yes,
Yes, my lord, that can be done. My lord, the allegation of the
everybody will be hard. Everybody will be hard. No
allegation of the petitioner that we are encroaching the PWD land in front of her property. That is not correct. That
is
yes.
Their allegation. Their allegation
Yes,
is that
yes.
it is encroaching.
Yes, that can be done. my lord. I have.
Petitioner has no allegation against you for the time being
Yes.
because you have been added subsequently.
Yes, yes.
There's no scope for allegation against you.
Yes.
Kothai?
Well, all interested parties,
They are encroaching, not you.
but practically they are not. Well, we have the shop room and in valid lease property, we have constructed. the shop.
Petitioners
Executive তো তোমাকে দিয়েছে
that
ডিএম না ওই লিজ হয়নি কে বলছে?
respondent numbers
তো সেই করবে তাহলে ওই ক্যান্সেল করে দেবে
9 and 10
না
have encroached upon PWD land adjoining their property. Stop. Respondent numbers 9, Learned Counsel for respondent numbers 9 and 10 submits that these respondents
পিডব্লিউডিতে করবেন
have no right, title or interest in respect of the plot in question and are not necessary or proper parties in the writ petition. Paragraph. The added respondents claim to be lessees in respect of the plot on the basis of lease granted in their favor by the KMDA. Lease has been granted to you
By the PWD.
by the PWD. Paragraph, the petitioner.
1375 সাল।
The petitioner submitted a representation before the concerned authority on 25th April 2022
আজকে টেনশন কোথায়
seeking clarification of the rival claims of the parties, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. State, no one is appearing.
No.
একদম শুরুতে none appears for
নদিয়া ডিভিশন
paragraph. Upon consideration of the
3 number
submission made on behalf of the petitioner and the private respondents, the writ petition is disposed of, directing the
division 1 respondent number 4 would be the opposite
executive engineer.
Yes, my lord. Page 17, I find, my lord, executive engineer wrote to the Nodia Highway Division 1, executive engineer, PW Road Directorates. These 4.
But he is not the authority to hear out. He can only file the report.
Tell a DM people.
So by the fourth respondent.
Yes.
DM is the authority.
But the representation has been made ADM.
ADM and executive also. Page 15, page 15.
Yeah.
Executive engineer.
Directing the disposed of directing the fourth respondent to consider and dispose of the representation. Presentation submitted by the petitioner dated such and such. Within 2 months
Yes.
from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner and the private respondents, in accordance with law.
My lord, in the event of any illegal encroachment, that should be.
Well, that yes.
Who is legal?
First decide.
Lordship.
Next.
Gift.
Grateful to lordship.
Item number 534. For my lord, I am for the petitioner.
Yes.
My lord, I have served upon the state respondents. My lord, this is my affidavit service, and after mentioning for upgradation, I have also served. No, সেটা কোথায়?
What about the private respondent?
I also again served, my lord.
Private respondent?
In my private respondent কে দিয়েছি মানে respondent number 6
Yes, she served.
yes my lord
And respondents have also been.
yes my lord I have sub
Yes. So they may. Yes.
my lord
What's the matter?
my lord unauthorized construction made by private respondent number 6 my lord on the PWD land my lord and for which I have made representation to the PWD engineer my lord and in earlier representation in my earlier representation engineer directed BLRO to demarcate the land of the PWD but till date they have not taken any steps
Demarcation has not been.
has not been
Yes.
and my representation second time I made a representation for demolition of the unauthorized construction in front of my Rayat land my lord they have encroached the land and for which obstruction has been made to my egress and ingress.
Affidavit of service. None appears for the respondent. Prescribed service. Mr. Dear's appointment regularized for copy service direction. The petitioner claims to be the recorded owner, paragraph 4, of the plot in question and complains that the private respondent has raised unauthorized construction by encroaching upon a portion of PWD land adjoining his plot, thereby obstructing his egress and ingress. The petitioner submitted a representation before the concerned authority in this regard.
Annexure P7, page 26.
On 10th May 2022, pursuant to which the assistant engineer, PWD, Kontai subdivision, by a letter issued to the Block Land and Land Reforms Officer, Kontai-Roman 1, block, on 15th June 2022,
Again on 7th.
requested, yes, sir, please wait. Requested the latter, LATTER, to make necessary arrangement for demarcation of the plot in dispute. Stop. No further steps being taken, the petitioner submitted a further representation before the authority on 6th February 2023.
Yes, get forward.
Seeking demolition of the unauthorized construction made by the private respondent. Stop. The said representation has also not been considered as yet. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Both the representations at the earliest form.
My lord, again BLRO has been directed to again on annexure 8, P8, page 27. My lord.
Further representation বললাম না pursuant কি বললাম এই জায়গাটা পড়ুন এর সাথে একটু অ্যাড করুন respondents pursuant to which the Block Land and Land Reforms Officer was again requested to arrange for demarcation of the plot by a letter issued by the Assistant Engineer, PWD, on 7th February 2023.
Good.
Stop. The demarcation is yet to be held. বাকিটা কেটে দিন তার আগে যেগুলো বললাম paragraph. Learned Counsel for the state respondents submits that the fourth respondent be directed to consider the representations. Yes. To take necessary steps for demarcation of the plot in dispute in accordance with law. Paragraph. In view of the above, Yes, 1 month and 2 months. In view of the above, this court is inclined to hold that since this court is inclined, in view of the above, the Block Land and Land Reforms Officer, being the fifth respondent herein, is directed to take necessary steps for demarcation of the plot in dispute and submit a dispute in presence of all concerned, including the petitioner, and submit a report to that effect before the fourth respondent within 1 month from date. Stop. The fourth respondent is in the event encroachment of PWD land or any portion thereof is found upon demarcation, the fourth respondent is directed to initiate proceedings under Section 10 of the West Bengal Highways Act 1964 and take the proceedings to its logical conclusion within 2 months from the date of receipt of the demarcation report, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, in accordance with law. Disposed of demarcation petitioner and the private respondent in presence of the petitioner. Next.
Item number 535. Well, I'm for the respondent number 1 to 7 in this matter.
I'm for the petition.
This is
I'm
the
praying for
petition.
extension of interim order. Your lordship has extended the interim order till 20th of December, man.
Well, one thing has to submit. Group 1 matter. Group 1 matter. Group 1 matter. You'll also kindly see in the. No, I'm also appearing group 1.
We are missing your lordship's matter because the group 3 matters have now been taken up by Justice Mantha, man.
Well, in this matter, you'll also kindly hear for 1 minute. In this matter, the same facts, one writ petition was filed in 2012. That was dismissed. It was restored, and thereafter, this final order has been passed in the writ petition. Before that, this writ petition has been filed. But after restoration, this final order has been passed. Same issue, same point. Well, same parties also, same issue. You also kindly see the last paragraph, last page. There are 3 pages. 3 last pages. Page 3.
There is a specific observation of the lordship, my lord.
Well, I have given the particulars.
Account should be given to me, my lord. Now, my lord, statement of dues has been given to me. Now, my lord, statement of dues has been culminated from statement of accounts, my lord. Till date, no accounts has been given to me, my lord.
Well, you'll also kindly see this is the thing we have given to them. Well, they have to raise an objection. It will be decided by the managing director. Well, after receiving it, even after receiving this.
We have served them with contempt.
Is this writ petition maintainable?
The same matter.
This was, my lord, dismissed, my lord.
And thereafter,
that junction, my lord, I was given a notice, my lord, for eviction, my lord, on that.
Disposed of, not dismissed.
No, my lord. Previously. It was dismissed, my lord. We have filed a restoration application, my lord. Prior to that one, we have taken out this application. Interim order was passed, my lord. Now, my lord, the previous writ application was disposed of with the direction, my lord, to give me, my lord, the statement of accounts along with, my lord, dues.
Well, that is my statement of accounts we have given.
My lord, your lordship, kindly appreciate, my lord. Kindly, my lord, come to.
It's the same prayer in this petition also.
No, my lord. Here, my lord, I am praying.
The appeal preferred before. Yes, it's the same prayer.
My lord, the appeal, my lord. Now, my lord, the accounts have still not been given to me, my lord.
This is the letter, my lord, so kindly see the accounts. Well, the letter has been given to them.
Kindly hand over me the letter which you have handed to lordship.
Where is the writ, the petition of in the earlier? I want to see the writ petition.
My lord, that is enclosed in this application, my lord.
Kindly see the accounts.
Still missing, my lord.
Well, can you see the accounts?
Given the accounts. Unless, my lord, the accounts are given to me. My lord, this is the dues of calculation sheet, my lord.
Let him file an objection and it will be heard.
Why, my lord? There is a clear observation of this court, my lord.
Unless it is lingering.
Liberty to file objection also.
My lord, after receipt of the accounts, your lordship kindly peruse, my lord, the order. It is very specific, my lord. Each and every occasion, your lordship kindly, my lord, kindly take your lordship's order.
His intention is to carry on without lingering the matter.
December 2023, my lord. Your lordship kindly takes once, my lord. The order, my lord, which has been passed by your lordship. The learned counsel for the respondent submits the report in the form of an affidavit shall
But how
suffice
can I
in
file a
respondent.
report unless it is disposed of?
My lord, he is holding the accounts. The documents are in his custody, my lord. He will not disclose the accounts. He will give me the statement of dues. Well, I have to reconcile, my lord.
Upon receipt of the accounts, the petitioner is at liberty to file
Yes,
objection.
my lord. Where is the accounts? Where is the accounts, my lord?
That is
Your
that.
lordship. No, my lord. This cannot be the accounts. Your lordship kindly sees the heading.
Let him file
Dues.
objection.
This is the dues. Your lordship kindly sees, my lord. Din action custody. Yes. How the dues has been culminated, my lord? The accounts will be given to me.
But he is a shop owner. But he knows how he has paid, how he has not paid. Let him file an objection. Let it disposed of. Both the petitioner will be.
My lord, give him, let him file the statement of dues, my
Maintainable, sir.
My lord, it is maintainable because, my lord, after perusing that application, my lord, interim order was given to me, my lord. Your lordship kindly appreciate.
After dismissal, it was passed. And thereafter, this order of disposal has been made. Now, this petition was maintainable if the application has been disposed of.
Chaudhary has made is very clear, my lord. The statement of accounts along with dues should be given to me. Only the dues has been given. Accounts has not been given. Until and unless the accounts is given, how can I reconcile, my lord?
Can you challenge that in a separate writ petition or you have to go in for contempt?
Prior to this, my lord, this application was filed. Prior to disposal of this application was filed. Your lordship kindly.
Therefore, but this application doesn't have any love. They appeared and they passed this order.
My lord, he has not taken the opportunity of filing my lord.
How
reply,
can I,
my lord,
your
now
lordship-
he's taken. Your lordship, this application has been filed on 31st July. This application has been filed, my lord, and the order has been passed. Your
It
lordship
will be
kindly see.
disposed of within a minute. Well, if he files an objection, it will be heard.
No, my lord.
Both
Why
the
should
matters
I?
will be disposed
Why
of.
should I, my lord? He
My lord,
should give
therefore,
the
my lord,
account.
his intention is to linger.
This application was
Intention is to
disposed on
linger.
13th of September 2023.
Is to linger. My lord, is only to linger.
Because, my lord, he is representing the authority. Authority is a right to enjoy whatever they will do, my lord. I have to accept it.
Objection file karo na bhai.
আপনি বলে দিন, you cannot file any statement.
দিচ্ছি তো
করিয়ে দিন কোর্টে।
তো দিচ্ছি তো whatever I have given, I have given. File for objection.
You have referred to two orders to impugn order. You have impugned two orders. What are they?
My lord, these orders, my lord.
Flag he has
my
not
lord,
paid.
I
Eviction
tell
order
you.
has been passed. Resumption order has been passed.
Initially, my lord, I was a tenant, my lord. My lord, outstanding dues of 1,53,000, my lord, settled upon me, my lord. In the meantime, my lord, I made an appeal demanding, my lord, the statement, my lord. My lord, Justice whatever as his lordship then was, my lord, has passed an interim order directing me to pay 50% of the assessed amount, my lord. I have paid 75,000. Justice Vishwas, my lord, as his lordship then was, made the interim
1st August.
স্যার আমাকে বলতে দিন। So, my lord, interim order was made absolute, my lord. In the meantime, my lord, till date, no accounts was furnished to me. The matter was dismissed, my lord. I had taken out a separate application. In the meantime, my lord, they have issued me a eviction notice, my lord. This is the subject matter of this application, my lord. This was state. In the meantime, earlier petition was restored. There was a direction, my lord, to supply me accounts along with dues. Dues has been given to me. Accounts has not been given to me till date. They say this is the statement of dues. You take it. Until and unless, my lord, the statement is given to me, how can I reconcile, my lord?
I find that the prayers in the earlier writ petition and this writ petition are
Similar, my lord. Similar. Your lordship kindly sees, my lord, the.
Since the earlier writ petition has already
Your lordship
been disposed
kindly.
of,
Your lordship kindly
how
come.
can this writ petition
Your lordship kindly sees, my lord, page 278, my lord, once, my lord, of this writ application.
page
278. Two 76 and 276 and 278, my lord.
Yes, these are the notices.
Yes, my lord. These are the notices, my lord. Subsequently, notice has been issued, my lord, on 19th of July 2023.
It is obvious, well, after resume.
First stayed, I find.
Pursuant to the order of this court, my lord, in this writ application, notices were stayed, my lord.
Yes.
And in the meantime, my lord, court has directed him to, my lord, to supply the accounts. Till date, my lord, no accounts has been supplied to me. Only statement of dues has been supplied. Now, my lord, your lordship kindly appreciate how the dues will, my lord, come on. After until and unless, my lord, I reconcile the accounts, I cannot ascertain the dues, my lord. It might be, my lord, they will be getting more than me what they have assessed, my lord.
You should have objection filed.
I have a right, my lord, to see the accounts. Authorities will shut me, my lord. They will not provide me any accounts.
Well, my submission is, my lord, this is the accounts which I have submitted to them.
Final report in the form
My
of.
lord, report, my lord, unless, my lord, if he doesn't file any objection to that, I shall file a report. You also can record that.
Accounts at all.
But this is the accounts which we are. This is the this is rent month by month. We have stated. You also kindly see the gone through that. It is there that we have given them the details. Rent, municipal taxes, GST, interest on rent, interest on municipal tax. Well, what accounts we shall give?
Please come back with an affidavit.
My lord,
Come back with an affidavit because you wanted to file a
my
report.
lord, my lord, the intention is, you also kindly consider. Intention is this. In this way, the interim order will extend.
But you should have been prepared with your affidavit today.
Well, my lord, without, my lord, if he says, my lord, if he says that we shall not file any objection to that, we shall file a report.
Here, you
My lord,
please come back with a report in the form of an affidavit as you asked, you said on the earlier date.
then, my lord, you also kindly consider this.
Instead of an affidavit and in opposition, it will be sufficient if a report in the form of an
Well,
affidavit.
that time I didn't know that the petition has been disposed of. The order has come to me. They have given me the order. The order have said that the entire thing has been disposed of by directing the parties same.
Let
But
it be extended for a limited period. Come back with a report. You should have been ready with your report today.
my lord, let them. But you also kindly see that they will not file any objection to that. File an objection to that.
Since your report is not on record, I cannot give any direction at all.
But in this way, my lord, they will get extension of time.
It's your lapse. You should have been ready with a report today.
Well, I have given the
Report in the form of an affidavit. This is a court, Mr.
as your lordship. If your lordship so desires, I can file it. But I shall file a report. I know at that time I didn't know about this that order, that disposing of the entire petition by directing the MD to consider.
An order passed by this court records that you have wanted to submit a report.
Yes, my lord, that time I was not aware that an order has been passed.
Documents. So annex the order, everything with the report.
As your lordship pleases.
For the respondents, seeks extension of time to submit the report in the form of affidavit.
But you also kindly record this also. They have given accounts, they have not filed objection.
No, I'm objecting
But
to
you
that.
also-
This is not an
you also-
accounts, my lord.
but this is the
I have
order has
to
been
extend to
passed.
that, my lord.
I have given it with my long back into
This is
2020.
accounts, my lord.
Long back, my lord, whether it is accounts or not, that
For an affidavit so that I can pass orders. This cannot be considered, Mr. Chotabada, you're aware. Paragraph, let the matter appear under the same heading on 19 January.
19 January.
Paragraph, the interim order granted earlier is extended till 31st January or until further orders, comma, whichever is earlier.
But the report has to be filed in the meantime.
In the form of an affidavit.
In the
yes.
meantime, as your lordship pleases.
Liberty was granted to you on the earlier date.
As your lordship, well, I shall file a report in this, but I thought that, my lord, they should file this objection and it will be disposed of as per the court's order. But they will linger the matter unnecessary.
Next.
Item number 536.
Lordship, I'm appearing on behalf of the petitioner. Mr. Adil Nasser is appearing on behalf of the petitioner. He has not come to court due to illness, Your Lordship. Kindly makes it not today.
After vacation, not today.
Your Lordship, there is some urgency. Your Lordship, kindly.
At all, sir. Otherwise, you would have mentioned, you would have.
19 January, na?
Are
Yeah.
you ready? Submit.
Your Lordship, I am not briefed in this matter. Your Lordship kindly considers there's some urgency.
Matter is adjourned. Paragraph, let the matter appear under the same heading on 25th January. Next.
Item number 537.
I am for the petition. I am filing the affidavit service and supplementary affidavit. I have sub copy of the supplementary affidavit.
Mr. Dev, the statement. Yes, what is the matter about?
The acquisition proceeding was initiated in the year 1962-63. Thereafter, in the year 1995, the respondent number 5 and 6 communicated later to each other that land of the petitioner was taken as extra land at the present stage, there is no necessity of land. Land may be relinquished. Thereafter, I made a representation. Let them, but your lordship, earlier I filed a writ petition earlier. Your lordship directed to consider my representation, and they have considered, and they kindly see the impugned order as page 50.
Page?
50.
Yes, what do they say?
The money was deposited, compensation money was deposited to the civil judge.
Yes, madam. But
You
I have,
will get the money.
I have two submissions.
You will get the money from the civil judge.
Where is the proposal for relinquishment?
Yes. Page 36, annexure P4. Is subject relinquishment proposal. And in the body,
Plot number 1471 is your plot.
yes. And in the body, last may be released of such land may be released as such the land may be relinquished to the petitioner. Dilip Kumar Kole and others, the petitioners herein.
At that moment, it was detected that that land was necessity. For the necessity, acquisition was made and money was deposited before the civil judge.
When was the acquisition made?
That is
62-63.
62-63.
Had the petitioner at length gone through the petition dated 8 April 2022 submitted by the petitioner, the conclusion is that the petitioner warned that the plot number Moja will be released in that. On verifying the relevant document, found that the subplot was acquired by DLA case number Hato. Payment notice was served upon Gaurmohan Kole, but Gaurmohan Kole did not receive the award amount and requested in writing to deposit the award amount to judge court. Accordingly, revenue the list was prepared and depositing the award money to the court. Thus, the process was completed.
The proposal is for release of 0.17 hectares extreme end portion of the acquisition line.
Yes.
Not the entire plot.
No, my plot is that part. Part acquisition was made. I mean, I have two submissions. But first of all, after 1995, there are no other communication that they have withdrawn this decision. And secondly, my lord, at the recent order, impugned order, they have prepared the list, but not deposited. Kindly see, my lord. Revenue list was prepared for depositing the award, but it is never stated that it has been deposited to the court.
Yes.
So, my acquisition is not completed. And possession is in our possession till date.
Not according to the indoor development, my lord, that is also.
But here are neither paid nor
Neither paid nor possessed.
possession taken.
So it attracts into development.
Position taken, we are in the position.
No.
Position taken.
This is
Paid means, my lord, deposited means paid. That is the indoor development.
Not deposited.
Please see the letter.
Yes, my lord, I have seen that deposited in the treasury is also a deposit.
Least
Not
prepared.
deposited. Please see the language. prepared for depositing,
Yes.
That for depositing the amount to the court.
not deposited. List was prepared for depositing. Where is the deposit?
My lord, that is the money was deposited is in the treasury.
No, no.
Money, my lord,
was
that is preparing, and where is the money?
There
Where is
could
the
be
money?
deposit.
Money is the treasury. Always, my lord, is the treasury. Money is not in the unaccounted amount.
There should be a deposit for.
That is the accounted money, my lord. That accounted, that will be accounted money, so it will be deposited to the treasury.
Where is the document?
This is not the unaccounted
Where is
money.
the document, Mr. Dev?
I will produce the document.
I am in possession, record of right is
How,
still,
how do you deal with
yes, 1995, there is no.
relinquishment document, page 36?
Yes, my lord.
How do you deal with page 36?
Relinquishment was not necessary, yes, because, my lord, after that, my lord, we have seen that the land is.
Not after that, Mr. Dev. Acquisition was in 62, 63.
Yes.
My lord.
Relinquishment in
If the
95.
acquisition is there, my lord, there is only provision for relinquishment.
It is your document.
Yes.
Whatever may be the document, my lord, that is not, he can't relinquish.
How can you ignore your
My
own
lord,
document?
that
You say that this portion need not be acquired, let it
Yes.
be relinquished.
This was taken as extra land.
Yes.
This is the language for widening.
My lord, the undersigned.
Page 36.
That is the executive engineer, Hooghly Highway Division. He is not the authority. Authority is the land acquisition collector.
No, no, requiring
That is
body.
the executive engineer to the superintending engineer. That is the internal procedure.
But this communication was in between two requiring body.
Copy is given to executive.
LA collector, copy is forwarded to the LA collector.
What is that?
This was the requiring body's communication.
He is the requiring body.
I am afraid the petitioner has a good case. Will you come back with a report? Will you come back with a report?
Yes, ma'am.
Showing the relevant documents?
Yes.
Let there be a report because affidavit of service and supplementary affidavit submitted on behalf of the petitioners are taken on record. Paragraph, learned counsel for the state respondent seeks to submit a report in the form of affidavit. Paragraph, let the matter appear under the same heading on 24th January.
My lord, in the next matter, I want consideration of.
Tomorrow.
Well, I have filed on supplementary affidavit be kept on record.
That's taken on record.
I shall not be important.
I cannot call for the matters now. Can't.
ঠিক আছে করে দিয়েছি।
Please call the witness.
Item number 598.
But I am for the petitioner, my lord. This is appearing for the first time.
Please serve and come back.
Yes.
Applicant petitioner is directed to serve copy of the contempt application along with annexure thereto upon the alleged contender and file a petition of service on the agenda date. Paragraph let the matter appear under the same heading on 16 January.
Yes.
Item number 599.
Yeah, for the writ petition. Lordship, this is the matter. Lordship will respondent legal metrology is here. Railways was 8812. Excellent. Boleni. Lordship will kindly recollect this matter, my lord. Lordship has heard at length. Lordship was about to reserve it for judgment, but somehow the railways and the metrology said that they will be producing some reports. Now, my lord, I was not served with any supplementary report. So,
my lord, I have communicated the order, my lord. Since the officer was ill, my lord, there was some communication gap, my lord, praying for some time, my lord. After 1 week after my lord vacation, I will file, my lord.
my lord, only one thing I
Kindly
will say,
grant
my
time,
lord.
my lord, as last chance, my lord.
I will say one thing, my lord, that they have already filed one report. That report is incomplete because the report does not discloses the condition of the weighing machine prior to the incident occurred, which is relevant. Now, second aspect is this, my lord, under the rules and regulations of the commercial manual, railways have their own department, mechanical department, where the officer concerned has a responsibility of verifying the condition of the machine by affixing a certificate to that extent. That has also not been annexed here, my lord. Now, my lord, the exercise which has been undertaken by the railways is absolutely illegal and against the rules and regulations, which I have highlighted in my exceptions. Now, secondly, my lord, there is a division and single bench judgment of this honorable court which supports my contention. And there is a, Lordship, I am praying here for refund of the punitive demand. So, my lord, kindly make it a last chance because railways are not here despite there is a previous notice by this one. Kindly don't allow them to make further report, my lord. If railway comes thereafter, then say I will also file a report, my lord, because they have lost this opportunity.
None appears for the railway authorities. Stop. No application is sought. Paragraph, learned counsel for the fifth respondent seeks extension of time to file a supplementary report annexing relevant documents. Paragraph, let the matter appear under the same heading on 15 January.
Lordship, a prior copy to be given so that I can utilize that time by filing an exception.
Copy.
My lord. 15th January.
Great.
Item number
Answer বন্ধু কোথায়?
100.
নাল নাম দেওয়া যাবে না। বাজু করে।
আছে আপনার I mean, none appears for the respondents.
I am here, madam.
None appears for the railways. Give your name. Yes. You are for the petitioner?
I am for the petitioner led by Shankarath Mukherjee.
On behalf of the private respondent number 9.
Yes, yes.
My lord, petitioner is a permanent permit holder. Made a complaint that the private respondent's vehicle is flying, violating the.
An appeal is pending before the Odisha High Court.
Odisha High Court, that is, my lord, I'm placing on documents.
My lord.
Recent documents.
Counter signature authorities West Bengal.
Has it been disposed of?
Yes, no, I'm placing these documents because the matter was heard on, my lord, 7th November 2023.
No order passed.
Nominate Standing Council of the Transport Department paid for further time for filing the counter affidavit because inquiry is required. Because through Bhagavan, not measurable. Every malware accident was occurred. A number of deed petition was filed. Who is flying the vehicle through Bhagavan? All those petitions tracked together and fixed up at the hearing. So, my lord, inquiry was made, and my lord, they prayed for time for counter file the counter affidavit. Matter was fixed on 24th January 2024. Kindly see the order.
In view of pendency of the appeal, the matter is being adjourned.
Interim order, there is interim order. Interim order is continuing.
The private respondents is continuing violating the alignment, my lord. My lord, kindly come to page 38.
My understanding failed to understand.
The
I have
change
Bhagavanpur non-motorable.
The change of route alignment was turned down. That has been that
We pray
appeal
for-
was
for
preferred
it-
against
for-
that order.
My lord, till
Yes,
today,
and that is pending.
We made an application for variation of the route.
till today,
That is
the
pending.
original alignment is exists, my lord.
So the matter will go out of list for the time being, liberty
Yes,
to mention.
My lord, till today,
No,
is
no, not affected.
he
No, no,
didn't,
his
he
permit,
didn't
my lord.
follow the alignment, my
No,
lord.
no, his permit from Holdia to
Kindly-
Bhubaneswar.
kindly come
I
to-
permit
my
Purmi
lord,
to.
kindly
There
come
is
to
no
page
class of
38, my
taxi.
lord.
Alignment is under challenge before the another high court.
Yes.
So there will be conflict of
The-
interest.
This is the
The alignment is not challenged.
the alignment shall because
Kindly come to page 38, my lord.
Change of alignment was turned down. That
Then
order has been carried in.
in
appeal.
street of Bhagavan,
That
that
is
contact was made application. That is
My lord,
pending.
till today, the alignment was, he is not permitted to fly the vehicle without Bhagwanpur.
Yes, that
Yes,
is,
that
that
is
is
not
challenged.
motorable. So this
Till today, he must be followed, my lord.
route is not motor, route is not there.
But kindly,
What is going on?
kindly, I am praying
Better
only
application.
interim relief, my lord. Kindly, he follow the
Respondent and the state respondents.
That is pending over.
That the appeal, that
আরে interim order আপনাকে চালাতে কোথাও বলেনি।
for the Honorable High Court
We
at
go south
Odisha,
there.
ODI
Before
SHM,
the High Court Supreme, Odisha.
has been fixed
He did not make him.
on 24th January 2024 for further hearing. Paragraph in view of the above, let the matter go out of list for the time being, liberty to mention. After
Liberty.
dismissal of the appeal, please mention. There is the conflict.
Yes,
of
ma'am.
interest, sir.
My lord,
Next matter.
he only followed the decision of the ST West Bengal countersigning authority. That was not followed by him.
I repeat, sir, that it has been turned down, then appeal is paid, so let that be disposed of. Next matter.
Item number 601.
601.
My lord, I am for the petitioner, my lord. Lord, I'll pray for my lord a day's accommodation, my lord.
জানো এই যাও
করিনি স্যার প্লিজ পেলাম হাতে এক্ষুনি
Why you are not ready?
just now my lord handed over the copy of the brief. A day's accommodation tomorrow, my lord, kindly. Tomorrow I'll do.
After vacation.
My lord, kindly, my lord. My lord, 15 minutes pass over then, my lord.
Not possible at all.
এখানে
I do not allow that in any of the matters, so I can.
Well, only thing is that, my lord, in a single representation, my lord, if you lordship kindly come to page number 17. Page number 17 is the representation by a stage carriage operator having stage carriage permit. Representation is there for curtailment of a particular portion from one starting point, and the another, my lord, where the the termini, another termini, they are for extension of certain route. So in a single application, prayer is for, my lord, if you lordship kindly come at the bottom, Bortoman route, Gungra থেকে পলাশি via চাপড়া, তেহট্ট পলাশিপাড়া, কাটেলমেন্ট, চাপড়া থেকে গোংরা. That is via চাপড়া, that variation.
Krishnanagar.
An extension Chapra থেকে Krishnanagar. Now this type of matter, this type of application, whether it can be, my lord, made or my lord, it is, my lord, can at all be entertainable by the, my lord, the authority. My lord, there is an order of my lord Justice Dipankar Dotto that in a single representation, আমি তোমায় কপি দিয়ে দেবো, আমি কপি দিয়ে দেবো, আমি দিয়ে দিচ্ছি তোমার হাতে. Now, my lord, this issue was came up before the coordinate bench, and my lord, kindly come to, my lord, first, second, third, fourth. আমি চেঁচিয়ে পড়ছি, শোনো. The petitioner prayed for curtailment of one part of the said route and for extension of the other part. He is agreed because his representation dated 19th of March 13 made in that behalf has not been considered and disposed of by the STA. Now, my lord, kindly let us skip over, my lord, next paragraph. Then, my lord, second page. Second page. In my understanding of the provisions contained in section 80 of the Motor Vehicles Act 88, a combined application for curtailment of a part of the route and for extension of the other part thereof is not permissible in law. Curtailment and extension amount to variation, and variation is permissible, keeping the termini of the route intact. That is, my lord, the section 80 subsection 3, including the proviso. Allowing the petitioner's prayer would amount to alteration of a terminus, which is not permissible. The Secretary STA, having regard to the facts and circumstances of the present case, is under no obligation to consider the petitioner's representation dated such and such. So this is the, my lord, the order of this court.
That petitioner filed two separate applications.
Yes,
Well, two separate representations before the authority.
yes,
Instead of passover, adjournment, file two separate
My
applications.
lord, I have a malad.
Yes.
I must humbly apologize, my lord. I was not valid.
You are not
Properly ready. I'm
You
not.
don't need to be further ready, isn't it?
My lord, whatever you lodge.
I'll
So-
not go into medicine.
so I have done the matter for yourself also.
In land determination, Mr. They does it for us, my lord.
Yes.
Here, in land determination, my lord, Mr. They does it for us. Here, my lord, my senior.
Here, Mr. Sen will do it.
আর লাগবে? এটা টুকে নাও, এটা
নিয়ে নিয়েছি।
তুমিও শুনে নিয়েছো।
The petitioner seeks consideration of a representation made by him before the concerned authority for curtailment of a portion of the route and extension of another portion. Stop. Of another portion. Stop. The petitioner
সকাল 3টের সময় পাঠাবো।
is a holder of
এসছে তো, আজ তো বেঞ্চ আছে তো, ডিভিশন করছে। বুঝছো? এই দেখো, এর মামলা হচ্ছে
This
পিছিয়ে
is permanent stage carriage permit.
পার্মানেন্ট স্টেজ কাজ।
Permanent stage carriage permit in the route Gongra to
গোংরা টু পলাশি ভায়া চাপড়া,
Placi
অরিজিনাল রুট।
via Chapra, Tehotto and Plasipara. Via Tehotto আর Chapra করুন। Via Tehotto and Chapra. He seeks curtailment of the route from Chapra to Gongra,
কভারিং at least 12 kilometers according to
covering 12 kilometers, and extension of the route from Chapra to Krishnanagar, covering 15 kilometers. Paragraph. Learned counsel for the respondents submits that
in a combined application.
Combined request for curtailment and extension as made by the petitioner in a single representation cannot be considered by the authority. Paragraph. The petitioner seeks to submit two separate representations before the concerned authority, being the secretary or the
চেয়ারম্যান হবে না স্যার? না না, কাটেলমেন্ট সেক্রেটারি নাকি বোর্ডে পাঠিয়ে দেবো, ভ্যারিয়েশন বোর্ডে পাঠিয়ে, রুট ভ্যারিয়েশন হয়ে যাচ্ছে তো।
board.
Board, because the condition of the permit when it is varied,
Yes.
that means almost new permit, so board, RTA board, yes, new route. Or that is one of this secretary,
Respondent.
chairman, yes, fifth, তাই হবে।
বলেন the petitioner seeks to
ট্রান্সপোর্ট অথরিটি নদিয়া।
seeking, requesting curtailment and extension of the route respectively, and prays for a direction upon the authority to consider both the representations at the earliest. Paragraph. In view of the above, the writ petition is disposed of with liberty to the petitioner to submit two separate representations before the fifth respondent within
3 weeks, my lord. In my lord,
Within 3 weeks
the
from
vacation
date.
is my lord.
Stop. The fifth respondent is directed to
Okay,
consider and
okay,
dispose of the representations within 6 weeks.
My lord,
within 6 weeks from the date of receipt thereof. Upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of, etc.
Great.
Get.
Yes.
Item number 602. No, not কাগজ দিয়েছে।
Last occasion, my lord was pleased to direct me to file a report. There is a report and
last lot of instruction সেটা ঠিক আছে রেকর্ড করেছে নোটিফিকেশন হচ্ছে অ্যাক্টিভিস্ট থেকে both are contact I can see
Yes, Mr. Mukherjee.
But I just received
50 and 20. You have received the report?
just I received, my lord.
You want to go through this and come back?
My lord, I think, my lord, it's required to be because, like, you know, because this is the discrepancy, how they have.
no change of route cannot admissible in the eye of law.
That apart, I am.
He has to file a fresh application because transfer of route then everybody comes for profitable route. Then entire system will be disturbed. That is why.
My lord, then my lord, this is
have to have
this is
apply
my
for
lord,
fresh
legal
permit.
questions. These are questions related to law. Whether the change of route is permissible or not, then this act says.
So please go through the report.
My lord, that's why, because my lord, if
An
the
exception.
law says, if the law says, my lord, section 80, your lordship kindly see section 80, subsection 3. The specific provisions say permanent permit holder may apply, your lordship kindly see.
Apply for change.
Section 80, subsection 3. Whatever, law, if the questions relate to purely questions of law, then I am on other factual aspect, your lordship kindly see, subsection 3.
Yes.
An application for vary the condition of any permit other than a temporary. I am a permanent permit holder. Temporary by the inclusion of a new route or routes or new area or by altering the route or routes or area. So, my lord, this is my right to apply for change of even route. So, statutory right is there, my lord. That apart, my lord, I argued on the point that the notification says the number of vacancies is 50.
But the order says 20.
This is the RT, the report from coming from on the RTI that says 22.
20 and 22.
Yes. Now,
20
22 means 28 vacancies still exist because this is subsequent to the notifications. They replied on the. So these are two aspects as to be. If my learned friend saying this section 80 subsection 3 is not applicable, then I have to argue on the points of law.
Not on the paragraph.
Do you want to use an exception?
But I think, my lord, I have to.
Report in the form of affidavit submitted on behalf of the fourth respondent is taken on record. Paragraph, learned counsel for the petitioners seeks to use an exception to the report. Paragraph, let the matter appear under the same heading on 16 January.
16 January, 1 week.
Next.
Report.
Item number 603.
Mr. Sattik Bhattacharya is appearing for the petitioner. His clerk informed me that he need to pass over for.
Possible, not possible, and I cannot name anyone. I have to say none appears because I cannot record anyone's name.
His clerk is there. He informed me.
Can I record the clerk's name? I cannot. None appears for the petitioner. Let the matter appear under the same heading on 15 January.
Item number 604.
For 604, my lord, I beg to appear for the petitioner. My lord, so far the
Respondent, my lord, state is the only respondent. I have served. Yes, my lord. My lord, the affidavit of service is yet to be affirmed as because, my lord, it is, my lord, not in format.
This matter?
Yes, my lord, it is not in format, my lord.
Sir?
I am undertaking to file it in course of this day.
Yes, what is
My
the
lord, the
matter?
writ petitioner before your lordship is one of the auto rickshaw operator as well as the secretary of the union. My lord, he is agreed by, my lord, the unusual issuing of, my lord, the offer letters to, my lord, each and every members who are intending to, my lord, fly auto rickshaw in the said route. My lord, I have made representations and, my lord, in a similarly situated writ petition.
Is it a legitimate grievance?
No, my lord, it is absolutely not, my lord, but your lordship, they, no, my lord, my lord, the only source of livelihood of the petitioner is, my lord, flying of auto rickshaws. Now, my lord, if, my lord, the number of auto rickshaws are extended to that extent where, my lord, it is hard to, my lord, find the passengers for each and every auto rickshaw.
Cap?
There,
Is there any cap, maximum number that can be given?
there has to be some vacancy by the created by the authority itself. My lord, we have made representations.
Where
Now,
is
my
the
lord,
representation?
yes, my lord. Demand note.
The representation.
12, page 12.
That is a demand of justice.
My lord, in
Not a
similarly, my lord, a matter, my lord, your lordship was pleased to pass
Where
this
is your
order.
representation, sir?
My lord,
This cannot be asked to be considered. This is a legal notice.
my lord, I shall make a representation as well. Yes, my lord, this is the order, my lord, which your lordship was pleased to pass in another writ petition.
Make a comprehensive
Yes, my lord,
representation. with the
that
authority
liberty
considered.
was given in that writ petition also, my lord. Same order may be granted, same liberty may be granted in this, my lord.
Very. Mr. Deva, let consider. Because I primarily do not find any legal bar in it. It's for the authority to decide, not the.
Yes, my lord, absolutely. It is for the authority because they are to consider our.
How many offer letters shall be issued? The authority has to decide, not the petition.
We can only ventilate our grievance. That is.
There has to be some legal bar, isn't it? That is not there at the moment.
No, not there at.
Let the authority consider.
Even we do not know whether the vacancies are still lying there or not, because as per my instruction, even I have pleaded in the writ petition, but more or less 300 auto rickshaws are operating in this route, my lord.
There is no notification that is going. Not calculated.
The petitioner is an auto rickshaw operator and the joint secretary of the Auto Rickshaw Operators Union. So the petitioner complains that the concerned authority is issuing huge number of offer letters.
Yes, ma'am.
Huge number of offer letters to auto rickshaws, to auto rickshaw operators in the route where the petitioner plies his auto rickshaw, comma, thereby affecting the business of the petitioner prejudicially. Stop. The petitioner seeks to submit a comprehensive representation ventilating his grievance before the concerned authority and prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondents submits. Who should consider?
Road transport.
The fourth respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the fourth respondent within 2 weeks.
Yes.
Within 2 weeks from date. Stop. The fourth respondent is directed to consider and dispose of the representation within 4 weeks. 4 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, which next.
Item number 605.
Similar situation, similar prayer.
Same matter. The same grievance.
Yes. In respect of another route. Route বলে দাও. This is from Aryadoh, Khiagat, Rottola and Rottola Dokhineshwar.
Same order, Jayant.
Route is different.
Yes.
Route is different. Your lordship is not defining any route.
No, I'm not defining the route. And the same respondent to consider.
Yes, madam.
Respondent number 4.
Grateful. This first of all, this one number 4.
Item number 606.
In this matter, I appear for the petitioner, my lord. The matter is covered by your lordship decision. On the last occasion when the matter was taken up by your lordship made the queries about the validity of the permit. Lord, I am handing over the copy of the permit which remain valid till November 2007.
Legible on the earlier.
Yes, my lord, this is the copy. Yes, copy. It remain valid November 2027. But I have given
This
the
is
copy.
an exception to the permit.
Yes. Identical matter, my lord. I have given the order passed by your lordship on the last occasion. But one.
Regarding the peak, regarding this matter.
Let them hear the petitioner also. Identical order may be passed. If possible, it can be heard by tomorrow.
Let all these matters be taken.
Yes.
Together.
Tomorrow the peak.
Date has been fixed. It is not known whether hearing would be completed or not.
The council says tomorrow.
Yes. I know that tomorrow is the date for fixed for hearing. All the other petitioners were called for hearing. It has been fixed tomorrow. Your lordship pass identical order so that it can also be taken up for hearing tomorrow. থাকবো আমি করে দেবো ওটা দিদি নোটিস নট
He will be present at the time of.
I will be doing the hearing of all other matters. Therefore, I can.
So why don't you consider adding this matter also to it? Because the result will be a common result, isn't it?
I think in all
to all these holders.
This matter may be taken up by the authorities at their convenience.
Not tomorrow.
I have no objection. I can argue the matter tomorrow.
Together.
Lord, similar direction may be passed. I think, Lord, I think if other matters have been heard and the authorities decided to dispose of it with a common order, this will be governed in this order also.
Yes. Absolutely. No. No question.
No, I am not insisting for deferring.
In fact, I insist that let it happen tomorrow.
It depends on the situation. On the last occasion, because of the heavy rainfall, it could not
be.
And excessive jam from Palsit to Baduan. I have to return from Palsit on that date.
Where is your representation?
My lord, representation, my lord, at page, my lord. Representation of 6th October 2023, annexed P8, my lord.
The date is also the same.
Same. Page 39. Page 39, Lord. 6th October. Date is same.
Sixth of, page 39 is the resolution. Where is your representation?
Page 36, I understand. Page 36, my lord. Page 36.
Okay, this is 6th October 2023. Yes.
Yes, Lord, Annex P8.
So the same order as
Yes.
last. Date of same also. Here also the second respondent will be there.
Yes, second respondent. Will decide the representation.
District Magistrate. Yes, same order.
Exactly.
Kaptai same order. Yes, next ma'am. Disposed.
Item number 607.
Yes.
Well, the permit, I'm a permit holder. Well, the permit was originally issued in the name of myself as well as my lord, one Mukti Guhorai. Now, the permit renewal application is route for Mathabhanga to Joyga. It has been issued by the State Transport Authority of West Bengal. Now, my lord, this was the permit was expired on 8th of November 2014. Now, my lord, I made an application for renewal of a permit. I'm under the petitioner because prior to the making of the renewal applications, the one of the permit holder, it is a joint permit, she has died. I annexed the death certificate. That was not the prayer that was not considered, that was kept pending. Your Lordship will find at page 11, the death certificate of one of the permit holder, Mukti Guhorai.
Yes.
Number, I made the application for renewal as well as praying for deletion of the name of that.
That application in the year 2023.
No, I'm telling, I'm coming. So, that application first renewal that was not considered as yet, kept pending. After that period, I went to the office in 2019. And because of the COVID at that point of time, the visitors were restricted to entry with the office. That was there. Sir, admitted facts. Thereafter, I made another prayer for deletion of the name of the erstwhile one of the permit holder. The representation, your Lordship will find at page 14.
Page 14, 2023.
Yes, ma'am.
There is the application for renewal prior to expiry of the permit.
But your Lordship will find, yes, your Lordship will find the page 12. Page 12, my lord, is the fees for renewal of permit. It is of, my lord, yes, 11 November 2014. That your Lordship will find that the applications.
Date person now application.
It is of both.
আপনি বলুন না।
Let the fresh application be considered.
My lord, that only.
Let him make a fresh application. That should.
It is already there, 2023.
That representations maybe consider that they have taken the decisions.
Submitted on behalf of the petitioner. Permanent stage carriage permit was issued.
তুমি ল্যান্ড কেউ থাকবে মানে মাটিরও খাবে গাছেরও পড়বে এটা কি যা বলেছিল
In favor of the petitioner and Mukti Guru Rai, R.A.Y., since deceased,
মানে গাছেরও খাচ্ছ তোমরা চষিও একটা মুশকিল
for the route Mathabhanga to Joygaon, Jaigaon, which was valid till 8th November 2014. Stop. Mukti Guru Rai expired on 16th September 2013. Stop.
এইটা কোথায় আছে এই যে এইটা চাইছি সেটা এটা তো
The petitioner has
এইটা যে চাইছি সেটা কোথায় আছে
submitted a representation before the concerned authority on 12th October 2023.
নভেম্বর 2019 ওই আছে সেটা তো আমার সেই চালানটা কোথায় এটা আনকি
For renewal of the permit as well as a renewal of the permit upon deleting of the first permit holder Mukti Guru Rai.
মানে ওই ডিপার্টমেন্টটা না ডিপার্টমেন্টটা বুঝছি না ডিপার্টমেন্টটা চলে হচ্ছে
Stop.
ডিপার্টমেন্ট
The representation is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph learned counsel for the respondents submits that who will consider?
What is the respondent number?
The secretary.
Second respondent, I think. Say it. No, second, no, sorry.
No,
Fourth respondent, but say it.
Fourth respondent.
The fourth respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the writ petition is disposed of, directing the fourth respondent to consider and dispose of the representation dated such and such within 4 weeks. Within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of with
But the affidavit of service be kept on record.
Next.
Item number 608.
Respondents?
So our manager is appearing for the respondent, state
For the petition, yes, madam, for the petitioner, here is my affidavit of service. I've served all the respondents. I made an application for contract carriage permit and I've also filed the requisites that has not been considered. Only this.
For contract carriage, where is your application?
My lord, page
It's 10, my lord. It's 10.
And page 12 is the filing of the requisites.
E1.
The application for auto.
Page 12 is the requisite.
Filing of the requisites.
You are asking for consideration of this application. Affidavit of service. The petitioner applied for contract carriage permit and deposited requisite fees, contract carriage permit on. When did you apply? What is the date?
Applied on 27th July 2023 and deposited on
27th July 2023 and deposited requisite fees despite which the application has not been considered. Stop. The petitioner prays for a direction upon the authority to consider the application at the earliest. Paragraph, learned counsel submits that who will consider?
Two, my lord.
And second respondent be directed to consider the application in accordance with law. Shop application. Paragraph in view of the above, the writ petition is disposed of, directing the second respondent to consider and dispose of the application submitted by the petitioner dated such and such within 4 weeks.
Within 4 weeks.
But there is no representation, my lord, in this matter. Only application is there, my lord.
You have to consider the application. Representation is not necessary.
Application along with the order, my lord, of this honorable court.
Yes, my lord, when I shall communicate, I shall give the order.
Yes, sir,
Junior
why communication will be required? You are representing them. You will communicate, isn't it?
Yeah, yes, I shall communicate. I shall also.
Within 4 weeks.
Within 4 weeks, ma'am.
You can comply within 4 weeks.
Actually, my lord, then my lord, let it be 6 weeks, my lord.
Within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of, which.
Very deeply.
Next.
Item number 609.
My lord, this is my application. But service has not been affected. My lord, if your lordship.
Come back after vacation. Since service upon the respondents is not complete, comma, let the matter stand over till 11 January, 10 January.
10 then. Grateful.
Next.
Item number 610.
610, I am for the petitioner, my lord. Yes, the affidavit in service. My lord, the petitioner before your lordship, petitioner is a registered trade union, my lord, auto rickshaw union, my lord. He has a valid route permit 239 Joka via Roshopunjo to Mujishar, my lord. Apart from this, there is a numerous auto rickshaw which is plied, my lord, without permit and without valid license, my lord. In this regard, my lord, when we are going to obstruct to them to not to do this, my lord, they have beaten up, my lord, beaten up us, my lord. In respect of this, my lord, one FIR has been registered. Page 44, my lord.
Prayer in the writ petition.
Prayer, my lord, to stop the unauthorized flying vehicles to the particular route, my lord.
Where is your representation?
Representation, my lord, page, my lord, 28. There is a numerous representation, my lord. Last representation, my lord, 11/10/2023.
At page?
Yes, my lord, there is a numerous representation, my lord. My last representation was, my lord, page 28. I have made a, my lord, chart, my lord, where,
October 2020.
my lord. More than 300 to 350, my lord, auto are playing, my lord, without any valid permit to the particular area. My lord, we have made the representation to the department. We went to the police station, my lord, the traffic department, they didn't care, my lord. Page 20. Page 25, my lord, I have made, my lord, a list, my lord, where is the auto has been plying, my lord, without valid permit.
Your autos are plying in the same route.
My lord, there is a two route, my lord. Apart from the route permit, these illegal autos are plying on the same route, my lord.
Your auto is plying in some other route.
My lord.
How are you affected?
My lord,
This has to be a public interest litigation.
no, my lord, there is the one is, my lord, Joka to, my lord, Muchishar. Another is, my lord, Thakurpukur to Muchishar. There is a these same route are connected in the same, my lord, point. Thereafter, my lord, it's went to the Muchishar, my lord.
Where is that stated in your representation?
I stated, my lord, representation.
The next page 29. Numerous auto rickshaw within the jurisdiction are operating without necessary permit license, thereby the violating the transport regulation.
This is from Thakurpukur to Bakrahat.
Thakurpukur to Bagrahat.
So where is the clash?
Thakurpukur and the my lord, there is a
Show me from the writ petition because I do not know Thakurpukur Joka.
my lord, I have made a sketch map in regard to this, my lord. Page 20.
Yes.
Lordship, sorry, Lord.
Page 39 is a sketch map.
39, Lordship. Joka Khalpul to my lord, it's a Muchishar. There is a pocket route and another route in my lord 75 route that has been ended in the Muchishar Bakrahat. In this route, my lord, there is a common and they have ended, well, they have flying my lord in the same route unnecessary without valid permit.
I cannot follow which is the same route. Please show me. Please demonstrate which is the same route.
My lord, keep it, my lord, not today, my lord. My senior will
Mr.
explain.
Devrush?
I'll
If
come
it's in
back.
the same route, he has a case.
No, this is not the same route. Lordship correctly says that another thing, my lord, on the basis of the objection raised by the petitioner's calculation, my lord,
Yes.
we have taken certain step, positive step, and seizing by number, seizing the auto rickshaw number 56 of number, and initiated proceedings, and also the criminal case also there. Lordship can see this is report filed by the police. Yeah, we can say from the petitioner. Okay.
100. This is 27517. This is with regard to another writ petition, not this writ petition.
This is WPH registered by 517.
And here it is 10082.
7517.
Yes, this is 10082.
First page, Lordship, can you see? First page of my report. And Lordship, correct by the last paragraph of the petition, brother, that the writ petitioner is the authorized holder of permit having route Joka to Muchisa via Swan. They are avoiding the actual permitted route as the actual route mainly goes through village area. They are not covering village area. They are not covering the route from Rasapunjo to Notun More, Purapur, Nojari. They are flying the auto to main road of 75 route, which does not fall under the permitted route, their route 439. Moreover, the other route having code 191 are flying with permission in the route much earlier than the route of writ petitioner. Thus, class is present between the route. Correctly observed that they are not flying their own vehicle on the road.
Please show me your permit.
Permit as page 20, my lordship.
This is from
Apart
Joka to
from this,
Bakrahat.
my lord, apart from this, my lord, this 300 to 350, my lord, the auto which is flying, my lord, in this route.
How they are prejudiced, I fail to understand. They are not following their own route. Now they claiming that somebody are operating in different details or something. First you operate your vehicle in own route.
Your route is 239.
my lord.
Yes. And the route of the others is not 239, it's something else.
Apart from the route, my lord.
It's route
This-
number 191 and 75.
My lord, apart from the 191 and 239, there is a playing, my lord, illegal auto, my lord.
How are you concerned, sir?
My lord, I have
Not
been,
playing in 239. They are not playing in 239.
my lord, I have made a, my lord, chart, my lord, where is
Of fact, my lord, we are seizing the vehicle.
25 and 26, my lord. I have made a, my lord, list wherein these autos are not having any permit.
If you are not individually affected, this is a public interest litigation. Please show me that you are affected by plying of these autos.
My lord, may I come back, my lord, with my principal submission tomorrow? My lord?
Come back after vacation. Yes, because prima facie it appears that they are two separate routes.
My lord.
You have to show that they are plying in your route, thereby you are being prejudicially affected.
My lord.
If that is not so, it doesn't like it becomes a compliance.
Lordship.
Lordship can record this, my lord.
Will you take
We,
this?
we have already taken steps on the basis of the objection. So let it be disposed of.
Lordship,
Why
may
not?
I come back, my lord, tomorrow, my lord, Mr.
After vacation.
My lord.
Tomorrow, not possible. Later.
Why?
Affidavit of service. The grievance of the petitioner is that several autos are plying in the route allotted to the members of the petitioners union without valid license, without valid permit, thereby affecting the business of the petitioner prejudicially. The petitioner submitted a representation in this regard before the concerned authority and prays for consideration of the same at the earliest. Paragraph learned counsel for the respondents submits that the petitioner, that the members of the petitioner union have themselves deviated from the route allotted to them by the permits, in the permits issued in their favor. Stop. The route covered by the alleged illegal autos is different from that of the petitioner. Petitioner, despite which the authority has taken necessary steps pursuant to the objection submitted by the petitioner, and as many as 56 autos have been prosecuted. Paragraph learned counsel for the petitioner seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading on 15 January.
Mark, Lord. Great.
15 January.
Item number 611.
My lord, I have a very short prayer, my lord.
Yes.
My lord, my affidavit service is ready, but could not be affirmed. My lord, your lordship, can you take it? But tomorrow, my your lordship can take it tomorrow.
Mr. Debra is appearing.
My lord, the private respondent is there. He has been served also.
Then after vacation.
My lord, kindly, my lord. I have urgency, my
I'm not allowing any of
My
them.
lord, I know it, my lord. At the first
Please do
instance,
not insist.
I
I cannot discriminate, Mr. Shamanta. Please do not insist. Since service upon the private respondent is not complete, comma, let the matter stand over to 8th January. 8th January.
Timetable, my lord, objection already is there. Lordship directly consider along with the private dispute. That is.
This becomes a ground for appeal actually.
No.
It will again come back. Next.
Item number 612.
Affidavit of service.
হ্যাঁ, হয়ে গেছে 612 ওইখান থেকে
Yes.
Madam Sahib.
No one is appealing.
আমি লেখা নেই সেটা উল্টো করতে করতে
May I request Mr. Debrah to appear in this matter?
I'm appearing.
Oh, you are appearing.
612. I'm appearing. Sorry.
Yes.
I have to be.
The facts relates to this is a vehicle which operating in an interstate route, was operating in an interstate route from Balasore to Madhakhali. So rather Madhakhali to Balasore. This was issued by the State Transport Authority Odisha, and the countersigning part is the State Transport Authority West Bengal. For a long period, this vehicle could not be operated because of disturbance in the mechanical disturbance was there. Now, the petitioner made an application for exemption of tax so far as this part is concerned. Now, that was considered, but your lordships, on the basis of my lord's directions, the taxing officer we considered this and remission has been given. Now, my lord, he made an application for giving the counter signature by this authority, and the taxing officer, while remitting the tax for that period, a rider has been given. The further tax has to be assessed either from the date of the giving the counter signature by this authority or as the date fixed by the authority. Number of the vehicle has to be started because the originating point has been given by the permit has to be started from Madhakhali. This is the state of West Bengal. Number of vehicle was at that point of time in the state of Odisha. Number of the petitioner brought the vehicle from Odisha and kept it in a garage to make some repairment, but because of when the vehicle could not be operated for a long time, this is now the counter signature at that point of time, though they have considered, your lordship's direction was that consequential relief is to give the counter signature. That was at that point of time, it was yet to be considered. In the meantime, my lord, the motor vehicles inspector intercepted the vehicle and imposed a tax and other penalties also. My lord, that was under challenge before my lord. Now, my lord, provisions is there for preferring the appeal. Now, my lord, there was two-fold challenge. One is on the basis of the computation by one of the motor vehicle inspector, the appeal cannot be preferred because the appeal must have to be preferred if I aggrieved by an order of a taxing officer. That was not the taxing. That was one limb of argument. That was, and other is this, my lord, under section 16B of the Tax Act, the provisions is there to release the vehicle on the basis of submission of a bank guarantee of a quantum and an undertaking given to pay the said sum within a period of 1 month. Now, my lord, on your lordship's order is that the lordship will find And your lordship also granted liberty because the order has not been served, that is taxing officer. Thereafter, the taxing officer's order has been served upon us, but that was not a certified copy. Your lordship was granted liberty not to insist, to prefer the appeal on the certified copy, so that this appeal can be preferred. Now, your lordship's order is at page huh? কোথায় আগেও তো রয়েছে দেখছি page 57
57 একবার 119
মানে page 119 sure 119
Yes, 119.
yes madam, page 119.
এটা হচ্ছে পেজ 57
পড়ে যাচ্ছে ওটা তো no appeal with funds of Bangalore, তাই তো? তো Bangalore সেটা কোথায়? Page 60.
Yes.
Now, on the basis of my lord's order, my client furnished the bank guarantee and an undertaking. You also will find at page 60 the bank guarantee and the undertaking. কোথায় 60 কোথায় 760 60?
Yes.
Your lordship will find that. Now, my lord, as well as my lord, petitioner preferred the appeal before the appellate court.
Yes.
My lord, these are statutory appeal. So, my lord, before the district magistrate, your lordship will find at page
133 is the impugn order.
appeal টা কোথায়? Yes, your lordship will find at page 63 that the
Appeal has been disposed of.
appeal has been disposed of, but the chance was not given to argue on this appeal, and my lord, the order has been passed, rather ex parte, and your lordship will find the order. Now, my lord, page 133, this is the order.
133 is the appellate order.
This order 133, এটা page 2, তাহলে এটা কি?
Yes.
I think 133 বলি তো কোথায় কোনটা 132 এইটা
page 34
মানে তো page 134 আগে দিয়ে দিয়েছে মানে page 134
Yes.
মানে the order passed on 4th October 2023, মানে it was served later on and it was received on the annex the envelope. Service হলো orderটা serve হলো. Well, lordship will find that an envelope, it was served on page 128, by which they served the copy of the order, page 128.
128.
Is the envelope which I have annexed here with page 128, by which the department, your lordship will find on the left hand bottom, dispatch collectorate Purbo Midnapur, and I received it on 15th
November.
Page 130.
15th November, page 139. 130, sorry, 130. This track report says, your lordship will find 130. date of delivery of to the addressee, 15th of November, your lordship has your lordship got it?
Yes.
15th of November 2023. Now, my lord, here, my lord, the only thing is that, my lord, I have challenged this order. The grounds has been there, my lord. If one is this, my lord, the ex parte decisions. No scope was given. The notice has been served, but before reaching therein, the decision has been taken. Well, one fold is this. Well, the other is this. Well, this is there, my lord, has to be considered the factual aspect, because, my lord, this read court hasn't gone whether the vehicle was there standing with the passengers or the vehicle was running or everything. That cannot be adjudicated by the. So, my lord, those are the grounds. Sorry, my lord. Sorry, my lord. Petitioner himself was there. Sorry, my lord. The petition. Yes. My lord, I have. But the other. Yes. Yes. My mistake. My lord.
So the question notice holds.
That part was not. But the other parts which I have taken, my lord, in this writ petition, that the factual aspects have not been gone into. And the calculation also made. My lord, the other points is this calculation has been made without taking into consideration that, my lord, the consideration, the vehicle was without counter signature standing there. And the decisions earlier by the taxing officer on the basis of my lord's order that the tax has to be calculated thereafter, either from the date of counter signature that I will show your lordship, or as the date fixed by the counter signing authority. Here, my lord, yet to be counter signed. No date has been fixed for giving the counter signatures. So that has not been considered by the district magistrate, my lord, while taking this appeal hearing. These are the points I am giving. And, my lord, another part is there, my lord, I need our interim order to the extent, my lord, the bank guarantee which has been given. My lord, it is appearing, my lord, the dates, your lordship, on the last occasion I tried to mention this matter because they have given, yes. Page 131, your lordship will find the কবে কত তারিখ বলেছে লাস্ট ডেটটা দিয়ে সেটা কোন পেজে বলেছে কি পেজ 131 করছে এটা ওকে জিজ্ঞেস কর
This is the calculation.
No, I'm just কোন পেজে No, this is that 15. কোথায় Where is that?
Mr. Devra, do you need to come back with a report on this?
No, the only
Your submissions here and
And my lord, regarding interim order is concerned.
it has been
They have not followed the 16B of the tax act. Lordship kindly see release of no court shall release the motor vehicle seized under this act unless a person whose favor motor vehicle release fund is the bank guarantee. Bank guarantee they have given equivalent to 1.5 including the additional and the amount of penalty for non-payment of tax and also an undertaking to make payment of the same within 4 weeks from the date of release of the motor vehicles. They have not done.
No, the appeal preferred. At the same time, no appeal heard. We prayed therein for adding interim order, not to invoke the bank guarantee till the disposal of the appeal. But that has been turned down. That has been prayed for. That has been turned down by the forum.
Now appeal has been disposed of.
Now appeal has been disposed of. Now the question is, your lordship kindly come to page 135.
To comply the 16B. Only my lord's order, 16B has to be complied with.
16B to
16B, you have complied partly. Only then
page 135, your lordship will find
give the entire money and then take back your bank guarantee.
the last paragraph, on considering the above facts as and observations, the undersigned directed to taxing officer and this is the order, your lordship. Purohitarpur to realize the difference of amount of the demand, so and so, sub and the calculated amount of the tax and additional tax paid for the period of demand to the calculated 17 weeks after so and so from the petitioner, that is registered owner of the vehicle, and also directed the petitioner to deposit the difference of tax and additional tax as calculated by the taxing officers RTO so and so within 1 month from the date of communication of this order. Now, this was communicated, but I received it on
15 November.
15th November. Now, I mentioned, your lordship, on the last week that the date by which I have to pay the tax, that is within a period of 1 month, that means on the 15th of December.
It is the 18th of December.
If my learned friend says that on the last occasion on, I think Friday, I mentioned this matter, and your lordship, at the time of rising, that's the matter to be taken up because this date fixed on 15th, I mentioned this matter. It was appearing in the list on 15th, and your lordship's observation was that it can be it will be taken up on the Monday. So as your lordship was not there so that's why it need not be taken up. So I prayed for an interim order to the effect that the bank guarantee is with them. It is not the case the bank guarantee not with them. Not to invoke the bank guarantee. Not to, because bank guarantee with them. I am not saying this, not to invoke the bank guarantee, only through that effect. And the vehicle is in this state. But what was the apprehension? The petitioner may fly out. So these
The statutes.
no.
It is
It is with them. The bank guarantee is with them. Now, I need to argue on this point that the appellate. I went to the appellate forum. I challenge. I got the order from the appellate forum. Now I am in my lord's court to challenge on some other grounds. So I need. I'm giving the. I have already furnished the bank guarantee. So even the assuming, if I fail to succeed in this writ petition, they have the right to invoke the bank guarantee.
It is not only bank guarantee, there is an undertaking along with the bank.
So that is there. But now I am in my lord's court, challenging the order of the taxing tribunal, but the statutory appeal. Now, this has to be gone into, your lordship kindly for a period, because whether the counter signature has been given. Now, in the meantime, that counter signature also given by.
Appeal could have been filed only upon complying with the provisions of 16B, isn't it?
Appeal.
Please come to 16B for once.
Okay. Subject. This.
Yes.
16B.
It is referred to in the court order in 119. The order says the petitioner is further directed to furnish an undertaking to make payment of the same within 4 weeks from the date of release of the motor vehicle. Your vehicle has been released.
That on the basis of the bank guarantee as well as the undertaking. But I am on that.
Have you abided by the undertaking to make payment within 4 weeks from the date of release?
No matter the moment, but that is Well, correlated. Your lordship kindly appreciate one thing. I prefer the appeal. Your lordship will find. Now I prayed therein.
You ought to have paid without prejudice.
Well, your lordship, well, your lordship kindly appreciate the bank guarantee is with them. After even expiry of the period of 4 weeks. Only to obtain after even expiry of 4 weeks, they could have invoked. But what I am with them, the bank guarantee is with them. It is not the case, it is not the case, your lordship kindly appreciate the bank guarantee with them. So they are this money which has been secured by the bank guarantee is with them. It is not the case that I did not furnish the bank guarantee, but the proficiency is there, but the bank guarantee is with them. Now, at this stage, if your lordship say, well, I preferred the appeal, now I prayed for interim order therein, that has been turned down. Now, the final order has been passed. My lord, I challenge the final order. But there is the other part that your lordship make a short period because of this fact. I'm not asking. After the vacation, your lordship will decide this matter. And for that period, your lordship allowed this bank guarantee to be
You
written
have
off
not complied with it. When was the final order passed and when was this order passed?
What is the final order passed, my lord, in the appeal?
Yes.
But I have shown that the final order passed on October.
The direction of this court was in September 18, 2023.
My lord, I prefer the appeal. And I prefer the appeal. But on the basis of your lordship's direction, I furnish the bank guarantee and the prefer the appeal. Your lordship will find that from
Bank guarantee, undertaking, and payment in terms of the undertaking. 3 things. You have given the bank guarantee, you have undertaken. You have not paid in terms of the undertaking.
Now, your lordship kindly see
It's only disposed of in October.
Now, your lordship kindly see in the appeal, I prayed for state of operation of that, but the provisions of 16B, that bank guarantee has to be written. That has been turned down. That has been turned down. Then the final order passed. Now, here also I prayed for that part, as your lordship say.
There cannot be any stay of invocation. Let Mr. Rudebra come back to the report. For learned executive service. For learned counsels for the parties. You have challenged the order, the appellate order, isn't it?
Order of
Order of the district magistrate, Purva Medinipur,
11th October.
passed on 11th October 2023 is assailed in the writ petition. Paragraph, learned counsel for the respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 17 January. Next matter.
If possible, affidavit in the meantime, in the form of affidavit report.
Yes, yes.
If the advance copy, then I will, because this has to be shortened.
Definitely.
But there is an apprehension, this has to be shortened.
Please have an
Item number 613.
Will I appear for the petitioner in this matter? But
Yes.
the lordship kindly look at page 10, annexure P1. Petitioner is the permit holder, which remained valid, column number 6, 30th November 2023. Page 10, annexure P1, serial number 6, permit. I'm the old permit holder. It remained valid 30th November 2023.
Yes.
Lord, next page 11. Lord, 27th of July 2023. I obtained the replacement order to place a new vehicle, which was allowed by the authorities, which is still remain valid. Left hand side bottom, 27th of December 2023, it remain valid.
Yes.
Now you can see the condition number 2 in the replacement order.
Yes.
The existing vehicle will not be withdrawn from the route till her model vehicle of BS4 placed so that commuters shall not suffer. This replacement order is valid. Giving validity, I purchased a new chassis, page 12. On 8th of November, I purchased the new vehicle and placed in the body building garage for preparation of body, which is going to be completed by February 2024. Next page, page 13, is the garage certificate. Said it will be completed by February 2024.
The existing vehicle is flying.
Existing vehicle is flying. Now I am facing the difficulty since a new vehicle has been purchased and is going to be replaced for replacement and renewal. I prayed before the authorities temporary permit so that vehicle can fly after 30th November 2023 because there is no permit at all now. It will be renewal. It will be renewed. I prayed for before the authorities for renewal for grant of temporary permit under section 87 subsection 8 subsection D, which is permissible pending renewal to meet a particular need. This is the condition of the offer letter. I prayed page 14 is the application and the prescribed application is page 15. But my prayer, let the respondent number 3 be directed to consider the grant of temporary permit for short period till the replacement is of a new vehicle for renewal.
Particular time must be there.
Yes, yes.
Till the display.
No. Well,
One year, after 1 year.
But,
they will
no.
in a
Temporary permit can be granted maximum 4 months. 4 months.
Replicated the time when I get them.
In,
Do not grant temporary permit
No.
when
in
permanent
the
need
facts
is
of the case, I prayed for
permanent
temporary
permit
period.
is done.
Let it be granted for 2 months.
Direct the authority to extend the
Very well.
validity of the.
Very well. I have no objection. I want to.
Till 31st January or like that.
No, till February.
28th February.
Yes, 28th February. Yes, you'll also direct them to issue a temporary permit till February 2004. My
lying in garage for bodybuilding.
Well, they have said it will be given by February 2024.
Where is, they have said verbally. They have
Yes.
said verbally, or is there any communication?
Or
That the
six-
vehicle
sir,
will
he
be
can-
ready by February?
Page 13. Page 13. But bodybuilding garage clearly said, this is a chassis number
February 2024.
February 2004 এর মধ্যে বাস চেসিসের বডির কাজ সম্পূর্ণ করিয়া দেব। Therefore, I prayed for a temporary permit. Let it be granted for 2 months or 3 months. The moment the new vehicle will be placed, it will be renewed.
Let it be till 29th February. Temporary permit.
Very well, madam. Very well, madam.
Yes, let a temporary permit be there till 29th February.
Yes, yes, madam.
Because the earlier permit has.
Yes, yes, madam. Beforehand it will be
No, permit has already done.
November.
November, yes. And they have given the replacement order with the condition it should not be withdrawn from the route.
Yes.
For which I prayed for a temporary permit. Let them grant it by within 7 days, Lord. I'm suffering now.
The petitioner is a holder of permanent stage carriage.
Yes.
Permanent stage carriage permit.
Number 6 of 9394. Number 6. Appears to be number 6 of 9394. Right inside bottom top. Lalgod to Howrah railway station.
In respect of the route, Lalgod to Howrah railway station.
Yes.
Which was valid up to 30th November 2023. Stop. The petitioner applied for replacement of the vehicle by a new one, which was allowed by the authority by a letter issued on 27th July 2023. subject to certain conditions, comma, one of the conditions being that the existing vehicle would not be withdrawn from the route till a same or higher model vehicle in bracket BS Roman 4/Roman 6 was placed so that commuters may not suffer. So the petitioner purchased a new vehicle
Page 12, right hand side top,
on
8th November.
8th November 2023 and placed the same before a garage for preparing the same for making it ready for flying. The petitioner expects that the new vehicle shall be ready for flying by February 2024. The petitioner, since the existing vehicle is unable to fly due to expiry of the permit, comma, the petitioner seeks a direction upon the authority to issue temporary permit in his favor so that the existing vehicle can continue to ply till it is replaced by the new vehicle. The petitioner submitted a representation in this regard before the concerned authority on
Page 14, 29th November.
where is the date?
Right hand
Oh,
side top.
yes. On 29th November 2023 and prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondents submits that the respondent number
That's what 3 below.
district magistrate will consider.
Secretary করবে authority বলো RTO district magistrate respond of 3.
3 is the district magistrate.
Yes. Respondent number 2.
Second respondent be directed to consider the application in accordance with law. Paragraph in lieu of the above, the petition is disposed of directing the second respondent to consider issuance of temporary permit in favor of the petitioner till 29th February,
29th
which shall be valid up to which shall be valid up to 29th February 2024, comma, in terms of the
replacement order.
application submitted by the petitioner before the authority on 29th November 2020.
But in the light of the replacement order granted to me in my favor, in the light of the replacement order, condition number 2.
In the light of the replacement order,
Replacement order dated
in the light of the replacement order
dated
issued in favor of the petitioner on 27 July.
Yes.
27 July 2023. You need to be heard.
But if the permit is granted,
Not necessary.
Lord, you also kindly direct them to consider and grant so that no hearing is necessary because
I said consider grant of permit. Yes.
Lord, may I
And
pray
also
subject?
consider the representation.
Lord, my subject to Lordship indulge me, I pray. Your Lordship directed them to consider the issuance of temporary.
Yes,
Would your Lordship
yes.
kindly direct them to issue a temporary for this period so that I may not face any further
In
hazards.
light of this order, so that
Very well.
that will suffice. Within 7 days.
Yes, Lord.
Within 7 days from the date of communication of this order.
দেবে এটা temporary permit তো
Disposed of it.
সেক্রেটারি তো
Within
করে
2 weeks, otherwise, court is concerned.
Next.
May I please, your lordship?
Number 614.
I am for the writ petition, my lord. This is my affidavit of service, my lord. I have served all the departments. My lord, this is a matter, my lord, the petition pursuant to one tender which has been floated by the Eastern Railway. My lord, I participated in that tender process, and upon submission of the bid, my bid was considered as the highest. And accordingly, my lord, an e-auction agreement was executed me and the railways. Thereafter, my lord, I was required to operate the parcel space on a single trip from Howrah to New Delhi. Not from New Delhi to Howrah, only from Howrah to New Delhi. Now, Howrah is the originating station and New Delhi is the destination station. My lord, that was executed in the month of July. Thereafter, my lord, I operated. There was no problem whatsoever. Now, my lord, all on a sudden, I was intimated, rather, my lease was terminated on the ground that I have overloaded one consignment in the month of August. The letter of termination came in the month of November. Till then, I was operating. The ground which was taken by the railways, that as you have overloaded, so we have terminating you on the basis of report by the New Delhi railways. Single overloading. Now, it does not stop on that. There are other aspects also. My lord, I have challenged the termination notice by way of a writ application, because after terminating my contract, my lord, they have issued a tender. That tender I have challenged. But that was pending before the same, my lordship. However, the matter could not be taken up on the previous occasion. There was an assurance from the bar that the tender will not be opened, because if the tender opens, the third party right accrues and I will be out of this. The challenge does not remain further. Then what happened, my lord? On the returnable date, they came and say that the tender has been opened. Now, unfortunately, my lord, from my side, my lord, it got discharged because none of the rates, my lord, matched with the reserve price. I did not participate in the tender. Now, my lord, after that, my lord, on the basis of my representation, they considered it as an appellate authority. They considered it as an appeal, and appellate authority's decision was passed. The single line order, which is a subject matter of challenge before this particular case. No matter, only thing is this, my lord, the termination notice speaks that there is a single overloading, which is as per the FM circulars, because I am governed by the freight marketing circulars, which says that in case of 3 overloading, not even seen in several other matters, they will terminate me. But before such termination occurs, at least they have to give me a hearing. That is also there in the FM circular 11 of 2022 and also in the standard conditions of contract. Now, bypassing that, my lord, they have terminated me on the ground that I have overloaded. Now, my lord, in the termination notice, they didn't bother me to intimate me, nor my version was taken into account. Now, the appellate authority has also taken a decision behind my back. Lordship, we will be stunned to see that appellate authority order is a single liner saying that your appeal is regretted. This is without prejudice. Lordship, that is, I have annexed here at page 85. Lordship, kindly see. This was issued when the matter was pending. Lordship has taken note of that. Now, my lord, after that, when this matter is, this is, I have challenged, my lord, this is at present before your lordship. I only want this is that, my lord, the rules and regulations needs to be observed. Because in the termination notice, my lord, will find, lordship, kindly come to termination notice, which is at page 70.
70?
70 of the instant writ application.
Yes.
Lordship, may I read the termination? This has been issued on 21st of November 2023. Now, my lord, it says that an agreement for leasing of 3.9 ton FSLR of 12381 up of the contractual period 27/2023 to 17/2025 at rate of 53,000 per trip for 3 days in a week, ex Howrah and Delias was executed with the leaseholder Messrs. Ma Netula Cargo Services and the Lesser Railway Administration. The subject contract was awarded through e-auction floated by this division. Based upon Deputy CVO TNR's letter dated such and such and letter dated such as mentioned that you have been penalized on account of overweight in the leased FSLR of the said train, details of which are appended below. My lord, kindly see the date of checking is of 18th of August 2023. The train number is this. Now, my lord, overloading has been stated, that penal charges has been recovered. So, my lord, the only and the sole charge. Now, for such quantum of overloading is deliberate act of violation of terms and conditions of the agreement. Such quantum of overloading in a passenger carrying train is not only a threat and damage to the railway rolling stock track, but also put a question mark on safety and security of traveling passengers. In this regard, clause 18.1 of the standard conditions of contract also included in the e-auction policy wide 28.3 of the FM Circular 11 of 2022, which is an integral part of the contractual agreement signed between the auctioning authorities, railways, and Messrs. Ma Netola Cargo Service Kolkata through IRPS auction leasing is appended below. Now they highlight the rules. The railway, the termination of the contract, the railway shall reserve the right to terminate the contract as a punitive measure without any notice at any time in case of violation of the terms and conditions of the contract or due to any of the serious misconduct, including but not limited to violation of the Railway Act, commissioning of unlawful act, or which is not in line with good industrial practices or in activity of moral turpitude, by the leaseholder forfeiting full EMD and SD security. Exercising the power conferred by the Railway Board through the above provisions of the terms and conditions of the contract, the competent divisional authority has decided to terminate the subject contract along with forfeiture of security deposit with immediate effect in terms of para 28.3 of the FM Circular 11 of 2022, as well as the clause 18.1 and subclause 17.3 of the terms and conditions of the contract. Subclause 17.3, however, the railway shall reserve the right to terminate the contract as punitive measures without any notice and at any time in case of violation of the terms and the conditions of the contract or due to any of the serious misconduct by the contractor. As such, railway administration, taking the cognizance of the excess weight of more than 100% of the booked weight, that is observing such quantum of overloading to the extent of 4,316 kgs, which tantamounts to serious misconduct and deliberate act of violation of the provisions of the contract on your part, has decided to terminate the contract of FSLR up along the forfeiture of security deposit with immediate effect. My lord, this was the punitive measures which has been invoked upon me. Now, my lord, the rules is very clear. The rule says, my lord, kindly come to page 31 of the FM Circular 11 of 2022. Page 31.
Yes.
31 is the, my lord, the FM Circular starts.
The relevant page?
Yes, ma'am, kindly come to page 42. 42, my lord. The relevant clause is at 28.2. Now she has found the railway shall have the right to terminate the contract agreement for any reason. My lord, kindly mark this word, for any reason whatsoever after serving 30 days notice to the leaseholder. I am putting this question to myself, my lord. Any reason also indicates punitive measures also. Now, my lord, what railway has done, railway has invoked 28.3. Notwithstanding anything contained in para 28.2, railway shall also have reserved the right to terminate the contract as punitive without any notice. Now, my lord, it's a case of single overloading. It is not that I have overloaded more than 3 times. It happened not here, it happened at New Delhi.
Where is the clause which deals with overloading?
Overloading. That is at page 62.
14.3.
14.3. Yes. My lord, 14.3, page 62. This is the freight marketing circular 12 of 2022. If overloading more than the permissible tolerance limit, that is 1 ton in case of parcel vans, and 5% of the permissible carrying capacity in case of SLR is detected of more than 2 occasions in any one contract, the contract shall be terminated with forfeiture of security deposit. For avoidance of doubt, contract will be terminated in case of detection of third overloading beyond the permissible tolerance limit. This is the clause, it is their rules. So, my lord, on the for only sole ground of overloading, my lord, it cannot be considered as that much offense. Had I done it on a repeated basis, I could have understood. They have invoked it and they have terminated my contract without hearing me also. But on the basis of sole overloading, Lordship, their action is not supported by the rules. It does not have the sanction of law. Now, my lord, the most interesting part is this. Lordship is aware of the Freight Marketing Circular 7 of 2021. Lordship will kindly come once again to page 62, clause 14.2. Regarding payment of consignments loaded in leased SLRs and parcel vans, the provisions of Freight Marketing Circular number 7 of 2021 as amended from time to time shall be applicable. Now, my lord, the entire overloading aspects and payment aspects is covered by 7 or 22. But I have annexed that also, my lord. Lordship, kindly come to page 76. Lordship, page 76 says, my lord, in a nutshell, may I place my submission in this way? My lord, if I load any consignment from Howrah, I have to deposit a manifest where I have to disclose the number of packages and the overall weight. Now, my lord, that is not the sacrosanct. What I say, it gets verified at the originating station. Originating station has a responsibility and a duty to discharge to re-verify my statements with their weighing machine that yes, that is within the permissible limit, because the rules is very clear to the extent that no SLRs or parcel vans which is overloaded shall be allowed to be carried to the destination station. Now, that has been done or not, that I don't know, my lord, because it is not, but the rules is very clear. Clause 1.1 of page 76 and 1.2, it says, the originating stations shall weigh at least 20% of the total lease parcel traffic loaded in SLR VPs on daily basis, in such a manner that the entire lease traffic originating from station, that is Howrah here, is weighed in rotation. In case of lease traffic, if en route loading is permitted, this provision shall also be applicable on en route loading stations. Now, my lord, next, consignments loaded in indented parcel van shall be weighed before loading. In case it is not possible to weigh the consignments at loading station, the concerned CPA shall record the reasons for the same in writing and also convey the message to the destination station. Consignments once weighed shall not be weighed again, except as per the provision of 5.0. 5.0 says it's a matter of private checks on the basis of vigilance direction. Now, my lord, no such thing happened here. Now, my lord, kindly come to next page.
Surprise check.
Page 77, my lord. Yes. This is also one of the most important aspect. Clause 1.5. If payment of SLR VP has been done at the originating station or at any intermediate station is found to be overloaded beyond the tolerance limit, the entire excess weight would be offloaded at the point of detection, and the consignee leaseholder will have to take delivery of this part consignment on as is where is basis at the point of detection of overloading. Railway shall not be responsible for any damage, deterioration or loss to the excess consignment due to offloading of the parcels. The entire cost of offloading shall be borne by the consignor, consignee or the leaseholder. However, no punitive charges shall be levied. If the customer carries out load adjustment at the originating point, overloading of parcel beyond the permissible limit shall in no case be allowed to be carried in the vehicle. So, my lord, I assume, my lord, they have conducted payment here. Had they found any overloading done by me, they could have intimated me. I could have made a load adjustment or I could have removed the excess materials. Because the rule says it should not be allowed to be carried because it compromises with the safety of the passengers. Now, my lord, whether they have done it or not, it's not clear. Now, my lord, all on a sudden, on August, on the day of dispatch, my lord, it was intimated by the Northern Railway that I have overloaded. So, I presume, my lord, whatever I have stated here has been re-verified by the railways. Now, again, it has been weighed there beyond my notice, my lord. I was not issued any notice. Now, they themselves are contradicting the two payments. Railway here is saying it's okay, it can be dispatched. So, when this dispatches something, it is assumed that they have carried out all the checks. Because they have the mechanism here, it is not their case that they don't have. So, when they have the mechanism, they ought to have at least carried out, or they must have carried it out and send it to the New Delhi, and New Delhi has imposed the fine. Now, on that basis, my lord, that when the two railways are at loggerhead with each other, that one is saying it's within their permissible, and another saying is that beyond the permissible limit, then at least I should be given an opportunity to place my grievances, because the incident occurred in the month of August 2023. I was terminated without any notice in the month of November. For these 3 months, they have allowed me to carry on with my loading, unloading. They could have instantly terminated me. That yes, you have committed a wrong, we will not going to allow you. But they didn't do so. They did it after 3 months, that too without any notice. There I join the issue, my lord, because now what they have done, my lord, I made a representation before the competent authority. That representation was treated as an appeal. In the appeal also, when the appeal was rejected, the matter is pending before your lordship. They should not have rejected it in that way, just like a one-liner. At least I should have been given an opportunity to place my grievances. And I am not saying that it is the rules which says. Lordship's order is there on this field, which relies upon the apex court judgments and the honorable division bench judgment. I have brought all those judgments. Lordship wants to see, I will bring those judgments. Now they say that I should be given a notice before such termination, because it was not an instantaneous termination. It was a well-thought decision which was taken behind my back. And it continues in such a way, my lord, the termination, issuance of tender, so that my right gets further prejudiced. Secondly, appeal gets rejected. Now they float another tender, which I have challenged it, which is at item number 626, which is going to be opened on 29th of December, when the honorable court will not be in sit. It will be after vacation, my lord. They will prejudice my right in every way, whatever they want. Because lordship will remember the assurance which was given by the railways themselves, that was not taken into. Now, my lord, the judgments are there. If lordship, I will only rely upon your lordship's order. Lordship has categorically stated in one of the lordship's judgment. I will not bother lordship with further thing. Lordship, kindly see, this is paragraph 9 I will rely upon. Lordship, paragraph 9, Lordship will kindly see.
Opposite of hearing.
Yes. Now, I only wanted that because, my lord, the exercise which was carried out by the railways is illegal. Because the mechanism they have here, but they didn't exercise it, or whether they have exercised it, that is they themselves have to say that. But thing is this, my lord, they have flouted, or by doing this, what they have done is this: they have violated clause 14.3. They violated clause 28.2, which speaks of 30 days notice. They violated clause 17.2 of the standard conditions of contract, which also says that notice has to be issued. They have violated clause 1.1, 1.2, 2.4, 3.2 of the FM Circular 7 of 2021. They have violated Article 14, 19, 1G, 21 of the Constitution. They have violated the doctrine of reasonableness and fairness, and they have violated the doctrine of natural justice. All these violations are there, my lord. And item number 626, my lord, another petition I have filed challenging the tender, because in this matter was pending, they again floated another tender to further prejudice my right. And it was
Same consignment.
same. Yesterday, my lord, was not there, my lord. I have taken an urgent leave from the honorable court, my lord. On the basis of that leave, my clerks went to serve upon the department. The department, despite seeing the leave, they refused to entertain. I will not receive the copy of the petition.
Let us hear the reasons.
And this is how they are prejudicing me year, day in, day out, one after another.
Let us hear. Yes.
But it appears from the order under challenge at page 70, my lord, that order has been issued upon invoking clause 18.1 of the Freight and Marketing Circular.
Page 85, I think. The appeal is under
Yes,
challenge.
appellate authority's rejection.
Yes, that is under challenge.
No, in order 70, my lord, page 70, my lord, it has been categorically termination.
That was also challenged in the previous writ petition.
Termination was made on the basis of the order That is at page 70, my lord.
That order is no longer under challenge in this writ petition.
My lord, the basic.
85 is under challenge.
No,
That has merged with appellate authorities order.
No, that has merged with the affiliate authority. Main order is this order. This is the main order, man. Under what circumstances this order was passed, my lord? It was written on the manifestation. They mention that less number of the articles and less amount, less weight. But at the time of detection at New Delhi, it is found that they have sent by practicing fraud and huge amount and huge number of the articles, my lord. So the order was passed upon taking into consideration that such quantum of overloading in passenger carrying trains is not only a threat and damage to railway rolling stock track, but also put a question mark on safety and security of the traveling passengers. So this is the grievous offense they have committed. In case of practicing fraud, overloading the goods in excess of the permissible limit, my lord. So under 18, clause 18(1), my lord. Page 52, place 81. 52, page 52 of the Freight Marketing Circular number 11 of 2022. Railway shall reserve the right to terminate the contract as a punitive measure without any notice at any time in case of violation of any terms and condition of the contract or due to any other serious misconduct, including but not limited to violation of the Railway Act, commissioning of an unlawful act which is not in line with the good industry practice and activity of the moral one. So it has been categorically mentioned in the said order that due to the huge overloading, my lord, there was a possibility of danger of the passenger and the train, my lord. And in such view, my lord, this provision was invoked by passing the order, my lord. The overload was 200%. If my lord kindly see that weight mentioned in the impugned order clearly manifests that over 200% overload was made, my lord. And in case of overload, my lord, there is no scope for detection at the originating center house station because I am placing one part of the.
Why the goods are not at the originating station?
No, there is no scope. That was to be decided. That was to be based on the manifestation.
Kindly come to page 74, man.
What?
75. The rules are there. 75 manual clause B. It's clear cut.
I'll come to the page 59, my lord. Clause 9.7. It will be, have your lordship got it? Page 59, 59, clause 9.7. It will be the responsibility of the contractor to ensure that total weight of consignment loaded in the parcel space is not beyond the permissible carrying capacity of that vehicle unit leased out to him between any leg of its journey. So there is no mechanism. I am clarifying this position, my lord. The originating station is Howrah station, my lord. The train used to be placed in the platform, my lord.
Page 75.
75. Page 75. Yes, my
Your
lord.
circular?
Yes.
This is your circular?
This is circular. Action. Auction catalog.
This is the manual, my lord.
Auction catalog.
Is the manual?
It's a manual. Railways manual.
Please come to clause B of page 75.
Clause B of 75. Railway receipts shall not be granted till goods tendered for dispatch have been correctly examined and which tenders are required to load their consignments, and the railway receipt should not be given till. I am coming to that point, Dara. A minute. My lord, kindly come to Freight Marketing Circular of number of 11/2022
At page?
at page 33. It is the Freight Marketing Circular number 11 of 2022 at page 33. Policy for commercial earning and non-fair revenue
contracts awarded through e-auctions. E-auctions. Here is the case is e-auction, my lord. He was declared successful tenderer on the basis of e-auction. This policy shall be applicable for commercial earning contracts, non-fair revenue contracts, and other leasing earning contracts. So this is applicable in case of lease.
So you say that the circular is not applicable in this case?
This is not applicable. This is the applicable. This is the freight marketing circular. The principle and policy laid down under this circular is applicable in case of freight consignment from one originating to another destinations.
Freight consignment is beyond or beyond.
Beyond, this is the special. This is
of the manual.
yes. This is the beyond. This is beyond. That's all. Beyond.
How can it be beyond the manual, sir? The manual governs everything.
আমাকে যা বলেছে on instruction I am submitting.
The manual governs everything, and the freight marketing circular should be within the manual, and there is contradiction.
The policy shall be applicable for this is
guidelines.
Manual is the guidelines.
Yes.
Manual is the guidelines, and circular is specialized for particular this purpose.
How do you explain the contradiction? You cannot go beyond the guidelines.
Because this is the special policy matter railway authority has introduced, my lord.
The manual governs everything, sir. I'm sorry. And there is another provision with regard to overloading in the manual itself. Please come to page 62, I think. Yes, 14.3 and 60, page 62.
Yes.
The same guideline that you're referring to.
That's it. This is all the freight marketing circular.
The same circular?
Yes.
Please come to 14.3.
Overloading more than permissible tolerance limit, that is 10.0 ton in case of parcelvance, 5% of permissible current capacity in SLR compartment is detected on more than 2 occasions in any one contract. The contract shall be terminated with a forfeiture of security deposit and for avoidance of doubt. Kindly come to 18.1. In exceptional circumstances, if it is a grievous offense.
There is the exceptional circumstance. Have you explained?
Because you have explained in our order that due to 200% overweight, my lord, there is a possibility of the life was in danger of the passengers. That has been stated. At 70, such quantum of overloading is passenger carrying train is not only a threat and damage to railway rolling stock track, but also put a question mark on the safety and security of the traveling passenger. That is our findings. 200% overloading, my lord. So we have invoked clause 18.1. Right? 18.1.
Page 52.
Page 52. 18 point, what 18 point states, my lord? Railway shall reserve the right to terminate the contract as a punitive measure, my lord. Kindly read the particular word used, punitive measure.
Isn't this contrary to what the other provision in the same circular?
No, my lord. This circular does not mention any punitive measure. This is the general procedure, and this is a special procedure in case of finding any grievous offense committed by the consignee.
When there is a specific measure for overloading, how do you take the matter under 18.1? 18.1 is
huge overloading.
18.1 doesn't say so. 18.1 says serious misconduct, etc. Overloading is dealt with specifically in 14.3.
Yes, overloading.
Yes.
But if it is in the nature of a grievous offense.
That is consequential.
Yes.
First is the overloading.
Overloading. Overloading. And if it is beyond the overloading, my lord, can you see overloading more than permissible tolerance limit?
Yes.
That is
On
and
3
5% of permit carrier capacity in case of is detected more than 2 occasions.
Yes.
More than 5%. There is a distinction between the two clause, my lord.
5% maybe 100%, 200% also. That is more than 5%.
No, in that case, my lord, it has been categorically mentioned punitive measure at any time violation of the terms and conditions of the contract or any serious misconduct. That has not been incorporated in this clause. Serious misconduct.
Where have you explained this serious misconduct?
There is no specific definition, But once it is found that the more than 200%, more than 20,
How has the person found it?
this is on the basis of, my lord.
Cannot be arbitrary, isn't it?
No, no, that is not arbitrary, my lord. More that we have explained that how what was the permissible limit, 3.9 ton, and actually detected is কত ton? 8 tons about.
So squarely covered under 14.3.
14.3 in case of general my lord, if it is exceeded limit, exceeded permissible limit,
Yes.
but in the nature moderate to the actual, there is no scope for danger and other of the train and all.
That is itself dangerous. Exceeding permissible limit.
My lord,
How do you differentiate? How do you
200% difference and 10% difference is
more than 10%?
more than 5% difference. It's not same because this is serious misconduct. Oh yes, I am admitting, my lord. I am admitting that what would be the guidelines and criteria for serious misconduct? There is nothing. It is admitted position. But it cannot be said that order was passed in violation of this procedure.
And the appellate order has been challenged in the writ petition. Where is the reasoning in the appellate order?
Subsequently, another order was passed by a basis.
No, that was email, but that is, my lord,
Another
in the
order was
accent,
passed.
বলিনি আমি,
বল না।
appellate authorities order which I have challenged, my lord. It's on 8th of December 2022. It is just a one-liner saying that it has been issued without prejudice. Now, my lord, when I have challenged this writ application, it came up for hearing before your lordship. After I have indicated this, councils and the officials were there. They have understood their follies. Now they are trying to justify that, and by justifying that, they again flouted their rules. My lord, kindly.
After rejection of the appeal,
Yes.
what is this order?
This is an order passed upon a fresh considering of the appeal, my lord. I have nothing to improve more. This reason order in connection with the result that appeal dated 30th November 2023. In a letter under reference, you were instantly informed that your appeal letter has been rejected by the competent authority. In this context, reason order has passed by the competent authority is case closed.
And that is after 8 days, after 6 days, when the in between the hearing took place.
The provision.
My lord,
I would like to have your authority before me in this court.
there is order
I
of
would like to see the provision.
Of
Your
the appeal.
divisional railway manager should appear before this court on the next day to explain these provisions.
for passing this order.
Yes, to explain how a rejected appeal has again been taken into consideration.
Then I have to take instruction, my lord. Let me give some time. I will take the instruction.
Don't you think this is seriously an illegal issue? You reject an appeal without hearing the person by a single one-liner. Then when the writ petition is taken up for hearing,
No, ওইটা
then
বলছি,
the order is
একবার reject করার পর
so maybe tomorrow you'll pass another order disposing of the appeal again. Some bright idea will come into their heads. Is this an authority or a layman? And he is supposed to be, unfortunately, the divisional railway manager, Eastern Railway.
না না না
The
ওটাকে
railway will
একবার
collapse
রিজেক্ট
under his
করেছিল
guidance.
একবার রিজেক্ট করেছিল আবার এই
He's killing the dead body once at that time.
Yes.
Person has died, he's killing again.
Then I may give some time and I will take instruction.
Please take this back.
Also, in the meantime, staying of the operation, my lord. This order should go, my lord.
Absolutely. Has to be stayed. The order passed by the Assistant Commercial Manager. Oh, he himself has also not passed the order for Senior Divisional Commissioner.
Yes. Also, kindly see how it's functioning.
For Senior Divisional Commercial Manager, Eastern Railway. On 8th December 2023 is assigned in the writ petition.
আবার ফেস রিজন কি করে করে চলে
gist of the order was communicated.
The said order
Gist of the order
rejects
communicate করেছিল।
an appeal
In order to
preferred by the petitioner without giving an opportunity of hearing to the petitioner by a one-liner dash them inverted comma open korun. You are hereby informed that your appeal dated 30th November 2023 has been rejected by the competent authority. Stop, inverted comma, closed. Paragraph, learned counsels for the parties submit that during pendency of the writ petition, the concerned authority being the senior divisional commercial manager,
Yes, ma'am.
Eastern Railways, has rejected the appeal for the second time on
On 14th December.
14 December 2023. Stop. This court fails to understand how an appeal which was rejected on 8 December 2023 was further rejected on 14 December 2023. Paragraph, learned counsel for the respondents seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading on 24th January 2024. Paragraph, the order impugned dated 8th December 2023 be stayed till disposal of the writ petition.
Yes. My lord, I'm grateful, my lord. Only one thing, my lord, item number 626. Lordship, what they did, they again floated a tender.
Let me call.
Lordship, and Lordship, only I say, my lord, one thing, my lord. Lordship, kindly stay the hands of the tender. I have filed the writ application challenging that. 626, same set of lawyers are appearing, my lord.
Yeah, I mean,
626, we are not happy. Mr. GHOSH is appearing in 626. Oh, sorry. Well, in the event it does not reaches, my lord, I will.
Group 7 matters are not many. Yes, next one.
Item number 615.
Lordship, from 615 to 619, these are all similar matters regarding e-rickshaw, your lordship. I am covered by your lordship. Order, your lordship.
E-rickshaws will never end.
That I don't know, my lord. I am not a party to this.
You don't need to be part of it.
But I have already filed, my lord, the application.
Lordship, let him be added.
I've already filed.
Last person is.
যেটা লাস্ট অর্ডার যেটা ইয়েতে ছিল ফারুক সাহেব যেটা করে গেছে সব আছে
মানে পার্টি করেছে কোথায়? ওটা তো ওইটাতে করেছে, এগুলো তো একটাতেও নেই। তো করে দিতে বল, আমি তো করে দিচ্ছি অলরেডি ফাইল। এই যে লিখে আসি আজকেই হবে।
You have not actually in so many words challenged the memos. Have you challenged?
Yes, your lordship.
13
Yes, your lordship.
Yes, 13 January and the
Yes, your lordship. Lordship will be kind enough to come to the ordering prayer portion, your lordship.
13 January. Oh, only 13 January has been challenged.
Yes, your lordship.
28.
It's 28, your lordship.
Yes, Mr. Mukherjee.
But I haven't gone through this. If your lordship find that they're the same, then I have no objection.
And
But
you are not a party.
I have filed, my lord, the application for intervention. Your lordship can see this. I have filed, my lord, and there is a wakalatnama. And in this case, my lord, in all these case, I have already filed the wakalatnama also. My junior has already filed the wakalatnama. My lord, your lordship, can it be enough to add myself as a party? I think the petitioner has no objection,
Yes.
because I am not raising objection to the order as your lordship
This
passing.
is the order.
Same
One
order.
to 10,
Aye.
I think everything is covered.
Yes, your lordship.
My lord.
Let him add a.
The application.
ওটাতে কি আছে আগে দেখেন কোন রেসপন্ডেন্ট হচ্ছে সেটা তো
You have filed applications in all the matters.
yes all 6 matters all 6 matters
Acha.
yes all 6 matters I have filed.
Let us
Yes,
see
your
what-
lordship. Yes, your lordship. Same order. And affidavit of service we kept on record. Action
I'll
নিতে
call
অনেক-
one by one. I'll call
Yes,
one by one.
that will be
Otherwise
helpful
they
to the
will give us-
court officers. Yes, sir.
এখানে থাকলো, same. It's only number two.
জানি না এরা তো সার্ভিস করেন না
Can নেই? ছটা কেন হবে?
এটা কোনটা আছে ইমন? এটা কোনটা আছে ফার্স্ট আইটেমটা?
Implemented as respondent number 5 or 6 আছে না?
রামরলি, ঠিক আছে।
3 direction of respondent number 3. Next case.
নে ওটা নে, ওটা নে।
এর মধ্যে থাকলো। Yes, next.
নেক্সট কি মামলা আছে কোনটা আছে কত নম্বর কি নাম আছে?
ইমন। Next matter. Next matter.
617.
তুমি একটা কপি নাও। কপি নাও পাঠিয়ে দিও।
16 হবে।
এটা কোনটা? প্লিজ এটা কোনটা? এটা তো ওই যেটা
ইমন 616. ইমন
করে দিও।
You have a copy, Mr. Mukherjee?
My lord?
Can you have a copy?
But yes.
The original is not there.
Imon. I think
Number to check করুন। নাম্বারটা নাম্বার is 3785.
এই যে তাম্রলিপ্ত কপি নিয়ে নিন আপনি তাম্রলিপ্ত কপি।
This is 20532. This is not of this one. Please don't give wrong copies.
This is the
2785.
নাম্বার স্যার পিটিশনটার নাম্বারটা শুনুন 27861 which
You have filed the application today.
day before yesterday my Friday. As a Friday it has been filed madam. This is the number.
Shall I make them not today only?
I leave it to your lordship.
Because applications are not there. অন্যগুলোতেও নেই।
That will be better, madam.
The applications
That
are
will
not
be
there.
better.
Lordship, for
then
one matter, the application is there. Let that order
That matter, yes, that order is being passed.
for 615. Let that there be not.
615, I'm disposing it out.
Yes, your lordship.
16 onwards tomorrow.
And the matter.
Not today.
Yes, I'm grateful.
Mr. Mukherjee, please ensure that.
But the applications has been filed but it may not be there. Let it be taken up tomorrow.
Not today.
No.
Yes, your lordship. And matter may
only
position, your lordship.
Only one.
I'm grateful.
It will be taken up to 4:30.
I'm grateful. I'm grateful.
But the copy, let the copy be এটা আপনার but the copy
In the first matter, please give him a copy.
one copy of the writ petition.
Yes, because his application has been allowed.
Yes. I'm.
So this is still 19.
This is still 19, your lordship.
19 will be not today.
19.
15 পর্যন্ত হয়েছে 19 পর্যন্ত নট পুরো করে দাও
আচ্ছা।
তারপরে the matter my lord the petitioner is a leaseholder with the railways my lord pursuant to such lordship petitioner was awarded a contract.
620.
Correct.
This is my affidavit of service my lord, all have received it.
Who is appearing for the respondents?
620.
Your lordship, I'm for this the respondent in this matter. I'm paying for this not today. My senior is not able to come today.
After
No, my lord, kindly do not. No, lordship, kindly.
any matter.
My lord, only not today, my lord. Only because I will be, lordship, petitioner will be prejudiced to a huge extent, my lord. Petitioner is very praying only for a platform loading covered by a lordship's own order. My lord will remember that.
After vacation. I'm not allowing any matter before vacation. Please do not ask me to discriminate. I cannot do it. It will be beyond my principle. On affidavit of service. On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 5th January. Immediately upon. Next.
Item number 621.
My lord, this is the same matter, my lord. Affidavit of service, all they have received it. It is not today, my lord, only not today. Oh, yes, come. That's okay. My lord, the petitioner here, my lord,
Yes.
is a leaseholder with the Indian Railways, my lord. My lord, pursuant to one tender which has been issued by the Northwestern Railway, my lord, petitioner emerged as the highest bidder. And accordingly, my lord, petitioner started operating the parcel space in between Howrah and Bikaner. My lord, thereafter, my lord, petitioner made one representation before the appropriate authority at Eastern Railway, under whose jurisdiction it is coming as a destination station, to avail the right of the platform loading. My lord. Lordship has remember vividly, my lord, this matter pertains to that 5 tons of perishable items should be given loading from the platform itself, because so far as the hard parcels are concerned, my lord, hard parcels are loaded from the siding. And if the perishable items are also loaded from the siding, Lordship, that gets attached with the train on the subsequent date. So by the time it reaches the destination station, the entire consignment gets damaged. So, my lord, as the Eastern Railway at present is allowing other operators, including the parcel van operators and the SLR operators, SLRs are of the small compartments, the petitioner paid from the similar benefit, my lord. Now, my lord, on the earlier occasion, there was a notification of the Eastern Railway restricting the loading and unloading of perishable items in parcel vans, taking into account the congestions in the platform. My lord, that was challenged before a coordinate bench of this Honorable High Court. My lord. That coordinate bench, my lord, relaxed the notifications, saying that it is arbitrary, because if when you are giving the same facility to other operators, you should also be giving the similar facilities to these operators also. Now, my lord, after that order was taken into consideration by your lordship in other matters, lordship has passed those orders, further relaxing, lordship will remember that matter, further relaxing those conditions, my lord, because there should not be any discrimination, because the railway board policy is uniform and its applicability is also uniform. So Eastern Railway cannot come out with a notification barring the few operators of their choice that they will operate and they will not. That cannot be done. If it has to be stopped, it has to be stopped for all. If it has to be allowed, it has to be allowed for all, but subject to the restriction imposed by the railway board. This much I have, the lordship has relaxed it. Now, those orders I have also annexed here. Now, my lord, thereafter, the coordinate bench judgment, my lord, I should be candid before your lordship, that coordinate bench judgment was appealed. That was taken before the Honorable Division Bench. My lord, the Honorable Division Bench has partially modified and devised a mechanism. Lordship, that order is there. I will just highlight your lordship that order. Yes, this is the division bench order, my lord. Ekটু দেবেন, lordship. Lordship will, this is the coordinate bench judgment, my lord, which was relied by your lordship. And lordship will kindly come. Yes, at internal page 5. Internal page 5 of the Honorable Division Bench order, single bench order. Lordship will find that, however, as an interim measure, we order that on a consignment to consignment basis, the respondent shall be free to approach the appellant railways with a representation that the cargo or a part of its perishable in nature, and that the whole or any portion thereof will be allowed to be loaded into the wagons not beyond the 4 hours of the departure of the train. The representation may also include the necessity of loading the cargo from the platform. If such request is made by the respondents not later than 12 hours before departure of the train, the railway shall consider it fairly, reasonably, and within the shortest period of time, not later than 6 hours before the departure of the train in accordance with law, particularly the 2014 parcel leasing policy. Now, my lord, this was the mechanism, my lord. This was subsequently, you kindly note this, this is as per the old policy, comprehensive parcel policy of 2014. Now, my lord, here this present date application, my lord, there is an e-auction, that e-tender has gone. Lordship, from now onwards, Lordship will remember all e-auction for a period of 2 years, they used to give us the contract. Now, my lord, following this division bench judgment, my lord, Lordship has also adopted that part. Lordship has passed in other similar matters this order. Hey, George, please. You know, at a division bench. Lordship, this is another writ application. Lordship has considered the division bench order and has applied that mechanism here also.
Yes.
Yes. Now, my lord, I would be praying for a similar order here in the present petition also. But my case is more strong rather than the previous one, because in the previous policy, there was a restriction, there was a power given to the zonal railways that you can stop the loading unloading. But under the current FM policy, my lord, that power has been taken away and it has been allowed universally. Now the question of restriction in that way does not arises at all. Only I will beseeching your lordship, will, if your lordship so desires, can pass an order as your lordship has passed in other matters.
Go through these judgments.
Here, Mr. Ghosh himself has appeared in the division bench also, my lord.
No, no, no. I was not appearing before the revision.
Yes.
You have not appeared.
No, no.
No, he has not appeared.
Oh, he has not appeared. In that case, my lord, I will be beseeching your lordship pass similar orders on the line of your lordship's order.
Let Mr.
Because
Ghosh
additional
go through
solicitor
these, judgments and
come back tomorrow, my lord.
Yes.
Tomorrow is a very short matter, my lord. I covered by lordship's order. Nothing more needs to be.
We'll be seeking an interim order in terms of this earlier orders, earlier judgment.
My lord, my only two submit.
Yes. Grateful. Yes.
Evidential service. Short learned counsel for the petitioner. Paragraph, let the matter appear under the same heading, Kalket Devdin, on 20th, for further consideration. Tomorrow.
Tomorrow, my lord. Grateful.